I am mentioning matter. My matter, my lord, item number 71 and 79.
Yes.
Matter is looking to take up to 70. My matter, I am not praying for any indulgence. You will also, I only pray that this matter may be listed on the next week. My lord, when
Whatever it will, if it is not taken up today, some other day it will be taken up.
today, my lord, up to 70 will have to
Whatever it is, I have to take limited matters. Thereafter, I have to take fixed matters.
I pray before Lordship for upgradation the matter.
Just wait for this week. Mention on Monday.
May I implement extension? The second time I am mentioning, my lord.
Yes.
Extension of interim order, my lord. Second time I am mentioning. And one application.
To be mentioned.
May I permit to mention one is second appeal corrected application, my lord.
Second appeal application.
Act application.
Yes,
Yes, regarding extension, it will appear as to be mentioned. Sub notice upon the other side.
My lord, permit me to mention regarding item number 87 and 88. They are claim case hearing matter. The matter in the year 2016, my lord.
Upgradation of listed matters.
At any day, my lord.
On Monday, you see, with regard to upgradation of listed matters, I have mentioned that. It will be taken up on
Monday. I have already informed Mr. Singh, my lord. At any day, your lordship convenient. At 2 p.m., my lord.
I on Monday. Okay. There are other matters fixed. So mention on Monday. I shall see.
Kindly, lordship, if you lordship, my lord, I am, my lord, the lady is, my lord, widow lady, he is not without
When
money,
you-
my lord. That's why
You mention on Monday. I shall see.
I have kindly to mention two MSCC matter, for inclusion.
Hearing.
Yes.
Yes. After 2 weeks.
For inclusion in the list, my lord, application.
Application. Yes.
And my lord, one hearing, ready for hearing, paper book has been.
Ready for hearing. Yes. After 2 weeks.
Application.
Matter, it's a second appeal. It's not
Yes.
really an
Application. Yes.
Lordship,
One for
Yes. Give it.
my lord, an application.
Yes.
Condonation of delay application. Lordship.
Yes. Take it. Yes. Item 5.
Lord, I am for the petition, my lord. Yes, my lord. Oh, yes, sir. Yes, 51. Yes. My lord, there are 3 applications, my lord, there, my lord. 2 are for substitution, and there is another one is for abatement, my lord, since it was filed much after.
Can 2, 3, and 4.
My lord, I'll just hand over a list of the applications and how they are being substituted in which application. There are numerous legal errors, but they are all on record, my lord. Please. Can 2, can 3, and can 4, my lord.
You are for the appellant.
Yes, my lord. Abatement. Abatement.
So far, can 4 is concerned, this is for recording the death of defendant number
6, my
pro
lord.
forma defendant number 6.
6, my lord.
Here it is pro forma respondent number 6.
Yes, my lord. Anuka Bhattacharya. I'm sorry.
Yes. So far, application can 3 is concerned
It's for
It is-
abatement, my lord.
for
Since it was-
recording death of respondent number 5,
Yes, my lord.
Lakshmi Pratima Moitra.
Lakshmi Pratima Moitra, my
Our
lord.
heirs are already on record.
Yes, my lord.
So no question of any substitution.
No, my lord.
Heirs are already on record. So what is the reason for delay?
My lord, that point of time, my lord, there was COVID, my lord, so it did not get the
No,
news, my lord.
see, you have filed this application when?
My lord, the CAN 2 was filed in 2022, my lord. And they have died, my lord.
Yes, 2018.
Yes, my lord. So there was a delay, my lord.
You have not explained that in your petition.
My lord, paragraph 10, my lord, that during the pandemic and we have no communication with them, my lord, as such. Moreover, it was a changed brief. As soon as I got it, my lord, I preferred this application.
Para 10.
Para 10 of CAN 2, my lord.
Yes, you are appearing for?
Which party, my lord?
Yes.
Respondent 1 and respondent number 2.
Respondent number 1 and 2. Yes, what do you say?
No, go.
Yes, record and order. Learned advocates for the applicant and learned advocates for the respondent number 1 and 2 are present. The applications being CAN 2 of 2022 is taken up for consideration. The applicants in the state application have prayed to delete the name of appellant number 1, Debashish Kumar Sannal, appellant Sri Swadesh Ranjan Sannal and Sri Debashish Kumar Sannal from the cause title on account of their deaths.
My lord.
The applicants in paragraph 6 of the application have stated in particulars the legal heirs of the appellant number 1 and appellant number 4. The applicants have further stated that the name of pro forma defendant stroke respondent number 5 be deleted on account of her death, and in her place the name of Pinaki Moitra be substituted.
My lord.
The necessary particulars are furnished in paragraph 7 of the said application. In the facts and circumstances, this application, the delay in filing this application is condoned. The abatement, if any, is set aside, and the application for substitution stands allowed. Let the name of appellant number 1, Debashish Kumar Sannal, name of appellant number 1, Sri Swadesh Kumar Ranjan Sannal, appellant number 4, Debashish Kumar Sannal, and pro forma defendant, Srimati Lakshmi Pratima Moitra be deleted from the cause title, and the heirs of the said deceased appellant, Sri Swadesh Kumar Ranjan Sannal, Sri Debashish Kumar Sannal, and pro forma defendant, Srimati Lakshmi Pratima Moitra be deleted from the cause title, and the heirs of the said deceased appellant, Sri Swadesh Kumar Ranjan Sannal, and the heirs of the said and deceased pro forma respondent number 5 be incorporated in their place and state as stated in paragraph 6 and 7 of this application. The amendments be carried out within a period of 2 weeks. So appellants and pro forma respondent number 5 are substituted. Yes, who? Yes, what
Lastly,
else?
yes, and the last
So pro forma respondent is there.
yes, my lord.
Yes, now can 3?
Can 3, my lord,
That is also same.
same, my lord, specifically for respondent number 5, my lord, I have
Anyway, so this application becomes infructuous.
yes, and also I have basically stated that abatement, if any, my lord,
Okay.
will condone, which my lord is.
The application can 3 and can 2 of 2025, can 3 of 2022 and can 4 of 2025 has become infructuous.
No,
And
no,
B,
my lord, can 4 has not become
no,
infructuous.
can
2 and
4?
3, can 2 and 3, my lord, is allowing.
No. Can 3.
Yes,
Can 3 has become infructuous and can 4?
it is there for the Onuka Bhattacharya, the number 6, my lord, respondent
Okay.
number 6.
And the can 3 stands disposed. Yes. Now can 4 is taken up for consideration. Here your appellants have prayed for deleting the name of respondent number 6 Onuka Bhattacharya on account of her death. Upon perusing the petition and upon hearing the learned advocates, this court is of the view that this application should be allowed. Thus, delay in filing this application is condoned. Abatement, if any, is set aside, and the application for substitution being can 4 of 2025 stands allowed. Let the name of pro forma respondent number 6 Onuka Bhattacharya be deleted from the cause title, and her legal heir being
Kaushik Lal
Kaushik Lal Bhattacharya as stated in paragraph 2 of the application be incorporated in her place and state.
Much of
The amendments be carried out within a period of 2 weeks. Can 2 সবই disposed হয়ে গেল, 3টা infructuous হয়ে গেল, can 2 and 4 disposed. তাও disposed. Yes.
Lordship, there are 2 applications. Can 2 and 3, Lordship. One is for substitution of the sole appellant and another is for setting aside abatement on condonation of delay. Now, Lordship, this is an affidavit in reply filed in connection with Can 2, my lord.
Anyway, you're for the applicants.
Applicants.
The other side is not here.
Lordship, before mentioning this matter, my lord, we gave a notice.
Anyway, let it be adjourned for the day. On the next day, I shall see. Yes, learned advocate for the applicant. Appellant is present. None appears for the respondents. However, in the interest of justice, the matter stands adjourned till 11/8/2026. Learned advocate for the appellant is requested to serve one more notice upon the other side.
Grateful, Lordship.
I am for the petitioner.
On behalf of Kumar Roth for the opposite party, I am.
My lord, in every occasion, 3 years,
Not
this limitation is pending, my lord.
He has not.
Kindly have a look.
Illness, my lord.
Last occasion, my lord, they have prayed for.
So this is for substitution.
No, this is not substitution, my lord. Substitution was allowed, my lord. Can 2.
So this is for what?
This is for limitation.
Oh, section 5. Yes, record an order. Learned advocate for the appellant is present. Time is sought for on behalf of learned advocate for the respondents. However, in the interest of justice, the same stands allowed. Let this matter appear on 11/8/2026.
Yes, my lord. Fix up any time, my lord. Kindly, my lord.
Under the heading application, it will appear.
Again, they will not come. Now,
I'm for appellant, my lord.
Yes.
My lord, I have filed an application for substitution application. Can 2. Can 2. Within time. My lord, respondent number 6, my lord, died. Has been died, my lord. Died on, my lord. and that 10 February 2016, my lord. And I have filed this application my lord, within time, my lord.
10th May.
10th May.
How many substitutes? That is can?
Can 2, my lord. On an old number, my lord,
It is
4743.
এটা item 54 তো।
Can 2. I don't hold can. It is a 2 guys.
So defendant, respondent number 6 died.
Died, my lord.
Okay, you are for the appellant.
Appellant.
You have filed it within the period of limitation. Yes, Mr. Mahato, you are appearing.
Application for condemnation of delay in filing the appeal.
No, that is there, but unless it is substituted, they don't have any right. The record will be defective unless substitution is allowed. Yes, record and order, learned advocates for the parties, you are for all the respondents are present. The application for substitution being can 1, can 2.
Can 2, my lord.
Can 2 of 2016 is taken up for consideration. Heard learned advocate peruse the petition file. Upon hearing the learned advocate and upon perusing the petition, this application for substitution stands allowed. Let the name of the respondent numbers, defendant stroke respondent number 6, namely Raj Bihari Jana, be deleted from the cause title on account of his death, and the years of the said deceased respondent as mentioned in paragraph 2 be incorporated in his place and state. The application stands disposed. The amendment be carried out within 2 weeks.
But also can 3 substitution application, my lord.
3 দেখি 3টা দেখি
And
3টা দিন
defendant respondent number
3টা আছে এখানে
হ্যাঁ 3841 and dependent is number 58 has been died my lord on 5th January 2019 my lord, and I have filed my lord this application
yes
4/4/19
yes within limitation.
within
Learned advocates for the parties are present. The application for substitution being can 3 of 2016 is taken up for consideration. Heard learned advocates peruse the petition filed. It is the contention of the appellants that the defendant respondent number 5 within bracket small h, namely Maloti Rani De, died on 5/1/2019. Stop. As the application for substitution is filed within the period of limitation, the same stands allowed. Let the name of respondent number 5H, namely Maloti Rani De, be deleted from the cause title, and the names of her heirs as mentioned in paragraph 2 of this application be incorporated in her place and state. The application can 3 of 2016, no, can 3 of 2019
yes ma'am.
stands allowed. The amendments be carried out within a period of 2 weeks.
My lord, can 4 my lord, this is your substitution application my lord.
Can 4 is also
Plaintiff applicant has been died my lord.
no. Is which party? Which party has died in can 4?
Plaintiff appellant my lord.
Plaintiff appellant number
1 died on my lord 12 May 2024 my lord.
when? 12/4 to
12th April, page 7, paragraph 2.
plaintiff appellant number 1.
Yes my lord.
Yes, learned advocates for the parties are present. This application is filed for deleting the name of appellant number 1, namely Shankar Jana, who died on 12/4/2024. Stop. Peruse the petition, hard learned advocates. As this application is filed within the period of limitation, the same stands allowed. Let the name of Shankar Jana, appellant number 1, be deleted from the cause title, and the names of his heirs, as mentioned in paragraph 2 of the application, be incorporated in his place and state. This application can 4 of 2024 stands disposed. The amendments be carried out within a period of 2 weeks.
এটা নিয়ে নিন এটা নিয়ে নিন
For the degree holder.
For the appellant lordship.
Yes, what is your instruction?
Lordship, first of all, the report that has been submitted by the receiver, Lordship will kindly take note that no measurement has been carried out.
Let me see.
No. Lordship will kindly see para 8 at page 3 of the receiver's report, Lordship. Of the special officer's report. Lordship at page 3, Lordship.
You see paragraph 8. What do you say?
I say, or they will say.
Oh, paragraph 8. Oh, you are the respondent.
They refuse the special officer to measure, and now that is make a point that receiver has not been taken measurement. Can you see the report? But it is not necessary.
Lordship, measurement can be done there.
So let me send once again to take the measurement.
Not necessary. It is admitted.
Lordship, it's nowhere provided, either in any of the deeds or in the schedule of the property. In the plaint, nowhere it is provided. What is the area of the office space concerned?
Why your client did not give the consent for the measurement?
Lordship, this I am not
The
aware.
answer will be their change of regime.
No, no.
Yes, yes. Because in the earlier occasion, this political party was not there. Some other political party was there.
Oh, the authorities, the officials are there. These officials are there.
Forget that those are gone. The chair is to be expected. Now the regime is this main thing. $2016, decree passed. 2026, I have not been allowed. Only 10 lakhs has been deposited. No mean profit. No occupation charges. Carry on.
So, are you willing to proceed on this report, or do you want a measurement to be taken?
Lordship, measurement has to be taken, Lordship.
Yes, record an order. Learned advocates for the parties are present.
Well, there should
Learned
not be, my lord, before that, my lord, there should not be any stay without any payment.
Learned special officer has filed the report. Peruse the report considered. It is pointed out by the learned advocate for the appellant that measurement of the suit property was not taken.
Well, can you record that?
Upon perusing
Appellant has been said that they refused.
Report, it appears that although surveyor was engaged by the special officer during visit, but learned advocate for the appellant stated that they cannot give the consent without taking approval from their client, and therefore sought time. Thus, the measurement of the suit property could not be done by the surveyor. Stop. As learned advocate appearing for the appellant insists that measurement be taken, the learned special officer who was appointed is once again reappointed for the purpose of recording the measurement of the suit property and also to make inquiries with regard to the rent prevailing in the building.
That part is there.
I'm
Second
just,
part is there.
once again, I'm just making it
At their cost, not at my cost this
Yes.
time.
as the survey could not be conducted due to delay caused by the appellant. The further remuneration of the learned special officer shall be borne by the appellant. Thus, the inspection is to be caused by the special officer upon appointing a surveyor and upon notice to both the parties and the learned advocates. Let the report be submitted by the learned special officer on 13/8/2026. Necessary instructions must be obtained by the learned advocates from their clients in the meantime, so that the inspection is not further delayed.
My lord is directing consent necessary by the client.
Don't delay the
Yes.
matter. Don't
Dignity,
delay.
my lord, the prestige of the High Court.
Don't delay the matter. You see again that no consent is taken.
And Lordship, the state
Consent. Court is directing a consent. They are above the High Court.
and Lordship, the interim order is expiring on 31st, Lordship. If that may be a
So when is the execution case fixed?
Lordship execution
It has
case,
not been, date has not been fixed. Can you don't extend it? Can you keep it on the, I will not execute.
Okay, come on the next day. I shall see.
Let him.
But I am for the respondents.
My lord, I'm for the appellant. The interim order has been expired on the last week, my lord. And
The applications that is CAN 4 and CAN 6.
my lord, the application of CAN 4 is under order 41, rule 27 for the
Yes, and
additional
CAN 6.
evidence, my lord. And 6 is for the extension of interim order, my lord.
Yes, you are appearing for
For all the respondents, my lord.
all the respondents. Are the paper books filed?
Yes, my lord. Filed, my lord.
Paper books are filed.
Yes.
My lord, may kindly fix this matter, my lord.
My lord, if your lordship be kind to fix a date for hearing of the same.
Yes, learned advocates for the parties are present. Paper books are not in the record. Have you filed in the department?
Department, yes, my lord, yes. Paper book has been filed.
আছে রেকর্ড দেখুন তো পেপার বুকস ফাইল বলে রেকর্ডের মধ্যে এন্ডোর্স আছে হ্যাঁ learned advocates for the parties are present as these paper books are filed and the matter is ready for hearing. Let this matter appear for hearing. এ দেখুন কবে ইয়ে আছে yes দেখুন কবে
56.
Application 4 is
the next ডেটটা দেখুন
for additional evidence, my lord.
সেটা থাক সেটা আমি দেখছি আগে একটা এক্সটেনশন আর একটা ইয়ে আছে
Additional of evidence, my lord.
Yes.
Order 41, rule 27.
– 17/8/2026 at 2 p.m. The interim order granted earlier stands extended till disposal of the appeal.
Grateful, lordship.
The application under Order 41, Rule 27 shall be heard along with the appeal.
Grateful, lordship. Take to name.
57, my lord. I am appearing for the appellant. This second appeal has not yet been admitted under Order 41, Rule 11.
Is there any condonation application?
Yes.
So that has to be disposed first.
Yes, my lord. And there was, my lord, the record were sent back for correction. It has come back after correction. There is a condonation of delay application. And your lordship.
Whose application is this? Your?
My application.
So have you served copy?
Yes, my lord, there was direction and this is affidavit of service. So, my lord, there is a delay of 200.
All the respondents are served.
একটুখানি দেখে নেবেন মে আই কাইন্ডলি মিলেছে দেখে নাও সার্ভিসটা হয়েছে তো সবার হ্যাঁ সার্ভিসটা খালি দেখে নাও
How many days delay?
274. There was no knowledge, my lord, of the appellant, and the moment he derived knowledge about the dismissal, I informed him that certified copy of the certified copy of the judgment and decree would be necessitated for filing
Delivered.
second appeal,
Delivered.
and it
Delivered.
has been delivered. And my lord, after my advice, he went to the court below and applied for certified copy on 4/6/22, and the second appeal has been filed on 29/6/22. Paragraph 4. He has no knowledge about.
Yes,
the
record an order.
Therefore,
Learned advocate for the appellant is present, none appears for the respondents in spite of service of notice. Let the affidavit of service filed be kept with the record. The application for condonation of delay is taken up for consideration. Our learned advocate peruse the petition filed. Upon perusing the petition and upon hearing the learned advocates, this court is of the view that sufficient ground is shown for condoning the delay. Thus, delay in preferring this appeal is condoned. The application Can 1 of 2023 stands disposed. Let this matter be placed before the Honorable Division Bench, having determination in the matter for the purpose of admission.
grateful to Lord, sir. Grateful to Lord, sir. Order 41, rule 11, and etc.
দিয়ে দিয়েছি নাম দিয়ে দিয়েছি
57.
So I'm for the respondent.
I'm for the appellant, your lordship. Praying for not today only, your lordship.
Yes, let it be not today.
Grateful.
Time in this matter, Mr. Ritendra Banerjee is appearing for the appellant. He's on the way, praying short passover.
Okay.
My-
Okay, other side is not here. Let it be not today.
$60 I'm for the petitioner, my lord.
Appearing for the respondent, lordship.
So this is my application for, my lord, condonation of delay, my lord. My lord, what has happened, my lord?
Can 2.
Yes, can 1, my lord.
Can two.
Can 2.
Okay, let me see.
Can 2, my lord. My lord, delay of 653 days, my lord. 653 days, my lord. My lord,
Almost
why,
2
my lord?
years.
Yes, my lord. My lord, why the delay was occurred, my lord? My lord, what has happened, my lord? My lord, suit filed by the plaintiff, that is my client, my lord, against the defendant, my lord, for declaring that the agreement executed between the parties stood already cancelled, my lord. That suit was decreed in my favor, and my lord, there was a condition upon the plaintiff to refund back the 6 lakh rupees at the time of given by the defendant at the time of execution of the agreement for sale. Now, my lord, the order was, my lord, the challenge by the defendant, my lord, appeal, first appeal, and that appeal was stood allowed, my lord. And, my lord, my cross appeal was stood dismissed. Now, my lord, challenging that appeal order, my lord, I filed second appeal before this honorable court that stood allowed, that stood admitted already, my lord. That stood admitted, my lord. Part of the order that, my lord, the refund of them, that the cross appeal order was not challenged at that time, my lord. That is the difficulty, my lord. For that reason, my lord, the delay has been occurred.
For that you have filed a separate appeal.
Separate appeal, my lord. That is the, my lord, main predicament, my lord.
Yes, which paragraph you have stated?
My lord, paragraph number, my lord. Paragraph 5. Paragraph 11, my lord. Paragraph 11. Paragraph 13 and 14, my lord. $648 days. 648 days. Such. At that time, my lord, the order passed in the cross appeal was not challenged, my lord. That is the difficulty, my lord. For that reason, my lord, delay has been occurred, my lord.
Milord, this is the order, Milord, which was admitted, Milord, in another second appeal, Milord. This is the order, Milord.
You have annexed that. in
Milord,
the-
I have annexed in my section 5 application, Milord. And Milord, this is the copy also.
So this order of refund was the counterclaim, order passed in the counterclaim, that was not under challenge.
Yes, yes.
Yes, what do you say?
Lordship, in my humble submission, we have used an affidavit in opposition to this application.
You have filed an affidavit.
Lordship, it is on record, Lordship. They have also filed and reply, Lordship. I will be humbly beseeching your Lordship to
Dekhi,
kindly
opposition ta.
take the affidavit in reply, Lordship. They are admitting in their affidavit in reply that if this second appeal continues, it will be harassing to my client, Lordship. That is on record in the affidavit in reply, paragraph 15.
Yeah, that
Dekhi,
is-
ye acha
that
affidavit
is
ta
the,
dekhi.
Milord.
Subject to your Lordship's kind sanction, Lordship, if an proceeding before the High Court is harassing, that should not be permitted to allowed or continued by this honorable court, Lordship. The Lordship kindly takes paragraph 15 at page 6 of the affidavit in reply. Last paragraph, Lordship.
তোমার copy না? That is the, Milord, typographical mistake, Milord. বুঝতে পেরেছি বেটা। একটু it is denied as alleged. হ্যাঁ হ্যাঁ ঠিক আছে, ওটা তো তুমি বলেছো না। আরে তোমার স্টেটমেন্ট তো আছে এখানে, ইয়ে দ্য অ্যানসারিং রেসপন্ডেন্ট ওইটা।
So the decree, eviction decree was set aside.
Yes.
The eviction decree which the plaintiff obtained was set aside.
Yes, was set aside. That
And
appeal,
by the
my lord, challenging that order passed in the first appeal was challenged before this honorable court, and that second appeal was admitted.
so
my lord.
eviction decree was set aside and the counterclaim filed by the plaintiff was dismissed.
There is no counterclaim, my lord.
No, the
There was a
deduction.
precondition, my lord, in the decree, my lord, itself, there was a precondition, my lord.
Oh, directly, that
Yes.
refund.
Yes, my lord. That the suit be and the same is decreed on contest, but without any cause. The defendant number 1 is hereby directed to quit, vacate, and deliver the vacant to peaceful and has possession of the suit scheduled premises in the hands of the plaintiff within 3 months from the date of the order, failing which the plaintiff is at liberty to put this order into execution. The plaintiff is directed to return the earnest money of 6 lakhs, deducting 10% considering his hardship over the same to the defendant, and the defendant is
So
directed.
that was also
Yes.
under challenge. That
Yes.
you have challenged that.
That portion, that 6 lakh refund of 6 lakhs was challenged in the cross appeal. My cross appeal dismissed, their appeal allowed.
Subject to your Lordship's kind sanction, Lordship, the appellate court, Lordship, in the order of the appellate court I have, it does not reflect that any separate cross appeal has been preferred before the learned first appellate court, Lordship. And in the ordering portion, it is reflected, if your Lordship may kindly permits me,
देखिए
Lordship.
appellate degree টা
This is the
Milord.
this is the degree of the
cross appeal is dismissed on contest.
Yes, Milord. That is there.
Lordship. In the decree
That the
portion,
instant title appeal
specifically
152 of 2019 be the same is allowed on contest, however, without any other question, and the cross appeal is dismissed on contest. It is there, Milord.
Yes, take down.
And your Lordship, only one more submission for your Lordship's kind sanction. In order to an explanation for a section 5 for condonation of delay, each day delay of each day has to be explained, Lordship, even assuming that the order before the learned before this honorable court, there is an order passed on 19th of December 2023 admitting the other second appeal, Lordship. And this present second appeal has been filed in the month of March, on 7th of March 2024.
There is 650 days delay.
Milord, I have stated, Milord.
That is to be seen whether the grounds which is stated is sufficient or not.
Yes, Milord.
That
I
is
have
to be
stated,
considered.
Milord. In paragraph number 11, 13,
It is
14.
not sufficient. Your
My
contention
humble submission is that from when the other appeal has been admitted by this honorable court, they were under the knowledge that this appeal has to be preferred. So from 19th of December 2023 till 7th of March 2024, there is no specific ground stated in their application as to the delay or why the delay has occurred for such period. Since on the 19th of December already the delay has
stated,
been
Milord. Paragraph number 11,
yeah.
13, 14, Milord. I have
I'll
stated.
record your objection.
Right. Grateful.
Learned advocates for the parties are present. The the application for condonation of delay being Can 2 of 2024 is taken up for consideration. Hard learned advocates peruse the petition filed. It is the contention of the appellant that earlier appeal was filed against earlier second appeal was filed against the judgment and decree passed by learned additional district judge, first track, second court Howrah, entitled appeal number 152 of 2019, reversing the judgment and decree dated 31/7/2019, passed by learned civil judge junior division, 6th court at Howrah, entitled suit number 1922 of 2015. Top. It is further contended that the second appeal, which was preferred by the appellant, was already admitted by the Honorable Division Bench of this court. It is also contended that the counterclaim filed by the plaintiff in the court, in the learned trial court, as well as before the appellate court, filed before the learned appellate court, the appeal which was dismissed in view of the impugned judgment and decree, which is under challenge in the instant appeal, being SAT 36 of 2024, the said judgment and decree are related with each other, inasmuch as by the impugned judgment and decree, the learned trial court directed the plaintiff to refund ₹6 lakh to the defendant. Upon perusal of the judgment and decree passed by the learned first appellate court, it appears that the appellate court was pleased to allow the title appeal number 152 of 2019 filed by the respondents defendants on contest and the cross appeal filed by the and to dismiss the cross appeal filed by the plaintiff. In the affidavit in opposition, it is contended that the application is not backed by law and application for condonation of delay is harassing, motivated, belated, and bereft of any reason of the delay of 648 days. 48 days. Stop. Upon hearing the learned advocates and upon considering the facts of the case, although the learned advocate for the respondent objects to the prayer of condonation of delay, but upon considering the conduct of the appellant, that the earlier appeal was filed within time and the said appeal being admitted and pending disposal, and that a certain mistake was made due to some wrong advice in not preferring the appeal against dismissal of the cross objection, this court is of the view that the delay of the appellant is bona fide. Stop. Thus, delay in preferring this appeal is condoned.
Grateful.
The application for condonation of delay being Can 2 of 2024 stands disposed. Let this matter be placed before the Honorable Division Bench, having determination in the matter for the purpose of admission.
Grateful. Grateful.
Grateful.
Lordship, learned counsel, Mr. Owen Banerjee appearing in this matter, Lordship. Last occasion, your Lordship direct to the both the parties to prepare on the report of the special officer on the next
Yes,
day,
if any
Lordship.
exception is to be taken on the report.
No, my lord.
Lordship.
Now, whatever I will submit,
Let me see the order, last order.
I will submit verbally, and I will indicate 2-3 things, nothing more, nothing else.
Okay, let me
And
see.
it is, my lord, pending since long. And my lord, although we have filed an application for my lord fixation of their my lord occupation charge.
That is why the special officer was
So
appointed.
they, my lord, obtained, got the advocate on record. Copy was served upon the advocate on record. But at the time of stay, I was not able to appear, my lord. They did not, my lord, show it to your lordship. Subsequently, my lord, we mentioned it to your lordship, and then, my lord was pleased to fix, appoint the special officer.
Earlier, you see, the inquiry could not be conducted.
Now,
Thereafter,
my lord, everything is over.
now second time, the inquiry is conducted, the report is submitted.
Yes.
Now, what was the earlier order? Let me
But
see.
everything is complete.
No, you see, on 1/7/2026, the parties were granted time to come ready on the report.
Yes,
The
Yes,
special
Lordship.
officer.
yes, my lord, we are ready.
Lordship, during the pendency of the matter, Lordship, interim order has expired, Lordship. I am
No, I am asking, what is the
Lordship.
present position? I am passing it over, Mr. Banerjee will come.
No, Lordship, kindly fix another date, Lordship. And Lordship, during the pendency of the matter, interim order has expired, Lordship. Lordship, kindly
See,
fix.
matter, interim order is for a limited period.
Yes, Lordship, kindly extend the order, Lordship, and fix the another date, Lordship.
Then let it be done on
I'm keeping it on 1st of August.
1st of August, Lordship, great, Lordship.
Are you ready to come?
1st of August is Friday.
Saturday.
Saturday.
Yes.
Saturday, Lordship, except Saturday,
If you are
Lordship.
willing to come, I can keep it.
Lordship,
Alright, let it be today at 3 p.m.
no, Lordship.
The Banerjee has not come. She's telling.
No, sir.
Okay, my lord, then my lord,
Any
kindly take it up in the next week, any date at 12
Any
o'clock. I will
yes,
do it.
Lordship.
Yes, learned advocates for the respondent is present. Time is sought for on behalf of learned advocate for the appellant.
সামনের সপ্তাহে করে দিচ্ছি।
The matter stands adjourned till 5. না অ্যাপ্লিকেশন হেডিং এ আসবে যেদিন অ্যাপ্লিকেশন নেওয়া হবে। হ্যাঁ, না application, okay, 4/8/2026
Yes, much obliged.
under the same heading.
Mother, kindly extend the interim order, Lordship.
When it will expire?
Lordship, expire 8th July, Lordship. Kindly
So
extend.
the interim order granted earlier stands extended for a period of 4 weeks or till further order, whichever is earlier.
Grateful, Lordship. Grateful.
4th August. 4th August. 4th August, my lord, would it be possible for your lordship?
Application under the heading application.
At 2 p.m.
No. In the morning,
As
11
your
or 11:30.
As your lordship desires.
60 I am for the appellant, my lord.
Let's section 5 application. One.
But I am for the respondent number, respondent, my lord.
Service is complete.
My affidavit. My lord, advocate on record is not present today, my lord. Advocate on record is not present today due to illness, my lord. I am praying for adjournment, my lord. I am for the respondent.
You are for respondent?
My lord.
Okay, not today. There are 4 respondents. Who is appearing? Maybe all the
all the respondent, all the respondent. My lord, I am for the appellant.
I am for the respondent.
Not application for under section 5, my lord, 14 days delay in preferring a second.
Court's objection will not condone.
63. Learned advocates for the parties are present. Hard learned advocates. The which one? Can 2?
Can 1. Can 2 is, my lord.
Can
Petition, that
the
will be after
application can 1 of 2025 24 is taken up for consideration. Hard learned advocates peruse the petition file. Upon hearing the learned advocates, this court is of the view that sufficient ground is shown for condoning the delay. Thus, delay in preferring this appeal is condoned. Stop. The application for condonation of delay being Can 1 of 2024 stands disposed. Let this matter be placed before the Honorable Division Bench having determination in the matter for the purpose of admission.
64, my lord, this is my application. 53 days delay, my lord. Application was served last 1 year. They are taking time.
You are appearing or Mrs. Chakraborty is appearing?
Mr. Amitabh Ghosh is appearing on behalf of the respondent, my lord. He is engaged.
Section 5. I'll pass it over. Or if you want, I can keep it at 2 p.m.
2 p.m. 2 p.m. my lord. Kindly keeps it at 2 p.m.
Okay, 2 p.m. Legal account 2 p.m. call করবে।
করেই আমাকে বেরিয়ে যেতে হবে। আরে আজকে এসডিওর সঙ্গে মিটিং আছে আমার। এটা করেই যাও। 4টার সময় করছি।
65, my lord, I am for the petitioner, my lord, appellant.
My lord, I am appearing on behalf of respondent number 15 to 18, my lord.
My lord, this is, my lord, an application under section 5 of the limitation act. Actually,
There are several respondents.
there are several respondents. You
Yes.
have directed me to serve.
Yes. Have you completed the service?
My lord, I have
Received any copy, my
My
lord.
You are appearing for?
Respondent number 15 to 18, my lord.
My lord, I have
To 18.
as per my lord's direction, I have served notice upon
So as-
learned advocate, my lord.
Learned
As per my lord's
advocate.
direction.
Anyway, as because respondent, you are for respondent, defendant.
Respondent defendant, my lord, 15 to 18.
Okay, as because she is appearing today, you
Well,
better serve a copy upon her. How many days delay?
My lord, actually, my lord, there is no delay. Subsequently, there is an amendment of the degree. My lord, that is why, my lord, there is delay. If you can see the original date, my lord, there is no.
Anyway, later come ready. I'm recording. Yes, learned advocate for the appellant and learned advocate for
certificate to the
respondent number. Yes,
15 to 18, my lord.
15 to 18 are present. The affidavit of service file be kept with the record. Let this matter appear on 4/8/2026 under the same heading.
Fine.
My lord, date.
4/8/2026 under the heading application.
Grateful, my
Serve her a copy.
I am for respondent number 2.
Item number 66, Lordship, the learned advocate on record has to left this court due to some personal difficulty. I am praying for this day's accommodation only.
Not
One
this
day
week.
accom-
Not this week.
So, Lordship, kindly mention not today, Lordship. If it's
Okay, not
acceptable.
today.
I am grateful.
67, my lord, I am for the respondent, my lord.
But I think the appeal itself can be disposed of exit any day because this application, the point is very short. We need not have a paper book also.
Why? Application, oh, it says section 5 only.
No. What happens, the appellate court, rejects my appeal on the ground that the revisional court of this honorable court has directed me to make a payment of cost. And for non-deposit, the appeal was dismissed. My sole and bold contention is, the revisional court which passed the order has directed that if you do not pay the cost, then the
Okay, one application is pending. Can 2?
Can 1 stay.
No, can 2 substitution.
That has been done. I think.
Sole appellant, my lord, died. We have not received.
You are
the copy.
representing whom?
I am the appellant.
Sole appellant.
Yes, sole appellant. Can 2 takoi.
No. This application is filed by you. This
Yes,
can
yes,
2.
yes. Can 2. This substitution has to be done.
So you are holding power on behalf of this
This
applicant.
applicant.
That is Badon Chandra Adok died,
Badon
leaving
Chandra.
behind these three
Yes.
persons
Yes, yes.
as the legal heirs.
Yes.
So let me see the order.
The order impugned.
Or you can come with your written notes of arguments.
Can be allowed, my lord. I'm not standing on the way as because their client has died. And my lord, a date be fixed when the hearing will be done.
Yes.
So come with your written notes. I shall hear out the appeal.
Yes, yes. My lord, dispense with filing of paper books. This is second appeal. My lord knows.
Okay, first let me see the impugned order. Thereafter I can dispense with. Hey, dekhi
Ekbar
memo ta
file
dekhi.
My lord, the order under challenge is order number 69 dated 29/6/2020. It's got a 1/2020. Oh, illegible. Council to illegible copy দিয়েছে আমরা করবে
একটা কপি দেবে ও অ্যাপ্লিকেশন ফাইল
তারপর আমার Let us see, my lord, the order number 69. The appeal court thought. (29/6/2024).
Yes, 69.
Yes, order number 69.
Yes.
Now kindly turns to the second page. That's the relevant part.
You let me see the order as a whole.
Yes. Type copy. আমার কাছে দেখে দিয়েছে দাদার কাছেও নেই বলে দাও আমরা করে দেবো ব্যাংকের কপিটা দিবি তো আমাকে কতদিন স্টে দিয়েছিল স্টে রিভিশন সিওর 25,000 যে সিওর অর্ডার
Do you have a copy of the entire copy of the order of CO 1795?
That is annexed to Can 1.
Can 1.
Yes. Kindly turns to page 53 of Can 1.
53.
53. The ordering portion upon which the learned appeal court went is page 62. লিস্টে তো ক্যান 1টাই আছে, ক্যান 2টা নেই। ক্যান 2 টাইপ করেন না? পয়সাটা তো আর কিছু জিজ্ঞেস করুন। আমাকে দিয়ে দাও। আমার এটা প্লিজ হ্যাঁ করে বার আমার বার করে দাও। আমি কি করবো পয়সা না আলটিমেটলি করে যত কেউ দেখতে চাই কি করবো বলবো তোমার করবো না কোথায় স্ক্যানটা স্ক্যান টু নেই প্রেসও করতে হচ্ছে তুমি স্ক্যান টু করবে স্ক্যান টু ভেতরটা যাবে অনলাইন নেই আচ্ছা তুমি তোমার ক্লার্কটা তুমি একবার করে ফাইল নাও একবার করে ফাইল নাও Now, fine, okay, I can do it. Satisfied. আমাকে ডিফারেন্ট লিমিটের সাথে আমাকে দাও প্রথম দিন ওটাকে নিয়ে কি করিস তারপরে যখন দুই চক্র হয়ে আসে আমাদের তখন 4টে 5টা পেপার আমার আমাদের ছিল দিয়েছি কনসেপ্ট করে দেওয়া আমাকে যদি আমরা
Yes, so what is the wrong in this order?
Milord, the wrong is, Milord, if my lord has seen page 62, Milord, 62, paragraph 12, Milord, this is the sum and substance which has been reflected
Now
in
the
the order.
question comes is, did you place before the appellate court that you had complied the order?
No, Milord, I have placed before the court that I have 2 applications before the Honorable High Court in this civil litigation application, where I say I plead for extension of time to deposit because I was out
So
of
what
time.
happened to that application?
Those applications, Milord, are pending. In the meantime, Milord, my appeal goes. Now, Milord, the question now, Milord, before is, Milord, this order, paragraph 12, the condition, Milord, which was imposed is...
When did you make those applications?
Milord, prior to passing of this order, Milord, kindly takes up page 63. That is one application for paying for extension of time to deposit the amount.
So was this placed before the appellate
Yes,
court?
yes, this was placed. Now, Milord, this is another aspect. First aspect is paragraph 12. Milord, the condition the appeal court said that the order of the Honorable High Court is that if I do not pay, the appeal would be dismissed. But it's contrary. Milord, if I do not deposit, the appeal would remain stayed. And Milord, it will not proceed. And if I deposit, it will proceed. So Milord, that's why I say, Milord, it's a very narrow campus. Milord, kindly fix any other day.
But this matter, may I say, this matter, my lord, can be disposed of subject to lordship's approval. Now, my lord, what happened? I filed a suit for eviction of a licensing. Rightly, wrongly, suit has been decreed. Against that, he preferred an appeal. Before the appellate court, he filed an application for amendment of the written statement. That has been rejected. Against that, he moved before this honorable court. 2 suit, 2 appeal, 2 revision application has been filed. This is one of the same. Now, this honorable court, the coordinate bench, Justice Mukherjee, Justice Dr. Mukherjee was pleased to reject the revisional application with cost of rupees 25,000 each. Now, that was the condition precedent to deposit the cost if you want to participate in the appeal. Now, thereafter, according to him, he filed an application for modification of the order passed by the coordinate bench in the civil division. But ultimately, he has not proceeded with. Now, appeal court has given an ample opportunity to him to comply the direction, ultimately not done. Appeal was dismissed for non-compliance. Against that, he preferred this second appeal. The order 41, my lord, ultimately appeal was admitted and stay was granted, and there was a direction to deposit the 25,000 before the registrar general. What I am on.
So the question is, at the time of admission, it was a conditional admission that the due cost be deposited.
Yes,
that has been deposited.
Where is that?
That is deposited before the registrar general.
If that be so, kindly set aside the order of the appeal court, lower appellate court. Kindly direct the lower, because it is in argument stage. Landed lower appellate court dispose of the appeal within certain time. Because he has not complied, that's why appeal was dismissed. When he has, in terms of the order of this honorable court, although the cost was direct.
Where is the order of the division bench? Let me see.
Order of admission, my lord.
Let me see.
That's in my.
No, no, no. এই রেকর্ডটা দেখি
সাহেবের ফাইল
ডিভিশন
সাহেবের
বেঞ্চের অর্ডার।
ফাইলেই আছে।
ফোনটা খুলে অর্ডারটা বার করতে।
ডিভিশন বেঞ্চে অর্ডার হবে।
It's order dated 21st of May 2025.
ওখানে আছে।
এটা তো আমারই কিছু বলছি।
আমি আন্ডারটেক করব।
Paragraph 4 of that order, admission order.
কুশল যেটা বলছে না সেটা দেখ এখানে হয়েছে, দেখ অর্ডারটা বার
এই নেটে আছে।
না ও তো সেকেন্ড ডেবিট অর্ডারটা বার করতে গেলে আমরা
So the division bench directed to deposit before this court, and the revisional court directed to legal to pay to the legal service committee.
if your lordship see once minute page 53 of the stay application, your lordship will find the order of the coordinate bench, my lord.
So this is the subject. This is the page 53. Yes,
Yes.
page 62.
Ordering portion page 62. Now, my lord, your lordship knows, my lord, ultimately I am the sufferer because I filed the suit for eviction. My lord, due to technical fault, he has not deposited the amount. Appeal was dismissed. He came up before this court. Now, my lord, kindly set aside the order of the learned lower appellate court and direct the lower appellate court to decide the appeal on merits within a period of 1 month.
That's why it can be disposed of. There are only one thing before kindly regularize this can to be allowed substitution.
Yes.
And another thing,
Learned advocates for the parties are present. Yes, anything?
no, only one thing. If your lordship once, my lord, may I just see once your lordship brief, my lord, the stay petition. Once, my lord, if your lordship don't. একটা জিনিস একটু দেখে নিন বোধহয় না না একটা জিনিস
Can 1, not can 2.
that is, my lord, can 1, my lord.
Can 1 or can 2?
Can 1. If your lordship once give your lordship brief. দাদা এক সেকেন্ডের জন্য দেব ওয়ানটা গো এক সেকেন্ড।
The learned advocate.
But unfortunately, what I am apprehending that, my lord, I have lodged the caveat, but they did not serve the copy.
If it is so, my lord, I am extremely sorry.
Sir, দেখুন sir.
Caveat service police.
And my lord, I have been told by the client why you lodged the caveat. When
Oh, before the division bench?
Yes. Your lordship knows when they are moving the stay, they ought to have given a copy to me.
Yes, yes. If the notice of caveat is received by them.
Notice of
Yes, there is an endorsement that there is a caveat.
একবার দেখি অন্য কেসের রেফারেন্স আছে।
এক দুটোতেই আছে।
Anyway, this was not pointed out to the honorable bench.
Give it to your lordship.
Since my lord, it's very technical and we are conceding because we have deposited the amount. Let the appeal be heard out on it.
Within 1 month because it is in argument stage, and kindly see the suit was filed when. I am the worst sufferer.
Learned advocates for the parties are present. The application can 2 of 2024 is taken up for consideration. This is an application for substitution filed by the applicants for on ground of death of the sole appellant. Death of sole appellant. It is the contention that the appellant died during pendency of the appeal on 27/5/2025. Upon hearing the learned advocates and perusing the petition, the application stands allowed. The name of the sole appellant be deleted from the cause title and the names of the applicant's legal heirs be incorporated and in place and state of the appellant as mentioned in paragraph 3 of the application. The amendment be carried out within 2 weeks. By consent of the learned advocates, the appeal is taken up for consideration by dispensing with the preparation of paper books and calling for the trial court records. This trial court records and the
Appeal court.
the trial court and appeal court records and filing of paper books. Stop. This appeal is directed against the judgment and order passed by the First Appellate Court in on 29/6/2024 in title appeal number 165 of 2011. Stop. It is the contention of the appellant that the learned First Appellate Court, without appreciating the letter and spirit of the judgment and order passed by this honorable court in CO
1795 of 2016.
CO 1795 of 2016. Stop. Learned advocate draws attention to the order dated 24/11/2022 passed by a learned coordinate bench in CO 1795 of 2016. The learned judge, while disposing the said revisional application, was pleased to observe and direct as follows. Set out page 12, set out para 12, page 62. It is the contention of the appellant that no such direction was issued upon the appellate court, or there was no condition that failure on the part of the appellant will make the appeal stand dismissed. Stop. Learned advocate for the appellant draws attention to the order of the Honorable Division Bench dated 21/5/2025, passed in the instant second appeal, where the Honorable Division Bench directed the appellant to deposit rupees 25,000 on or before June 10, 2025, before the Learned Registrar General, which will be subject to the outcome of the pending application with regard to extension of time granted by the revisional court and for condonation of delay in filing the said application. Stop. Pursuant to the admission of the appeal, the appellants have complied the order dated 21/5/2025.
On record gives an undertaking to produce the receipt, deposit receipt. That's he's not carrying right now, but he can produce, my lord, any day, my lord wants.
As submitted by the learned advocate, although the said receipt is not produced, and it is submitted that the same will be filed in course of the day. Stop.
একটা কপি আমাকে দিয়ে দিস।
Upon further perusing the order passed in the revisional application in CO 1795 of 2026 and the order passed by the Learned First Appellate Court on
order number 29/6/2020
on
29/6 2024
মেমোটা বার করো না, মেমো
29/6. How can it be?
29/6/2024
29/6/2024. 29/6/2024. This court is of the view that the learned judge of the First Appellate Court erred in dismissing the appeal and not keeping the same in abeyance. Thus, the judgment.
If you actually record my submission once.
Yes.
Madam. Now, madam, kindly see page 62 once.
Yes.
Madam, kindly see paragraph 12.
Yes.
CO such and such is accordingly dismissed with cost of rupees 25,000. The petitioner shall deposit the cost 25,000 to the Calcutta High Court Legal Service Authority within a period of 4 weeks from the date of communication of this order as condition precedent for further proceeding with the appeal.
Yes, yes, yes.
Therefore, this is the
So,
condition.
Instead, thus.
Can you record my?
No, the learned advocate submits that although learned advocate for the respondent submits that the appellant was under obligation to deposit the cost within 4 weeks, but considering the fact that application for extension of time was made before the learned coordinate bench which passed the order, the appeal ought not to have been dismissed, but it could have been adjourned or kept in abeyance. Could have been adjourned or kept in abeyance. In view of the compliance of the order of the Honorable Division Bench dated 21/5/2025, the order dated 24/11/2022 stands complied. Thus, the judgment and order of the learned first appellate court
title appeal number 165
passed in title appeal number 165 of 2011 dated 29/6/2024 is set aside. Stop. It is hereby made clear that this court has not gone into the merits of the appeal and all points will be kept open to be considered and adjudicated by the learned first appellate
since
court.
it is pending since 2011.
As the appeal is pending for a long period, learned first appellate court is requested to dispose the appeal expeditiously and preferably within a period of 4 months.
And can it be because the division bench directed within the coordinate bench directed 2 months. It is in the argument stage. But 2011 suit was filed in 2000. But I will show.
Okay, within 3 months
yes, sir.
From date without granting unnecessary adjournment.
Yes. আচ্ছা লোয়ার কোর্ট রেকর্ড কল করা হয়নি তো
না এলসিআর কল করা হয়নি তো
একবার দেখে মে আই জাস্ট সি ওয়ান্স মাই লর্ড
এলসিআর আসেনি তো ডিসটেন্স করে
না ওখানে অর্ডারে যদি কল করা হয়
হয়নি
দেখে নি বাবা একবার
হয়নি
নামটা দিয়ে দে
My lord, my lord. And for the appellant insurance company, my lord, there are 2 cans, my lord, which had to, this matter had to be mentioned under the head application, my lord. Two applications are there in these 2 matter, my lord, of the change of name, my lord, that has to be disposed of first.
Can 1 and can 2.
Can 2 of 2026, but there are 2 appeals, same accident.
And 1 is for?
Can 1 was stay application.
Okay. You see, the entire security, entire compensation is deposited.
My lord.
So that will continue. And with regard to 2 also, sales and
my lord,
application you have made.
Yes, change of name, my lord.
No, both arise from the self-same award.
Accident, yes.
Incident is the same. There are 2 claims. 2 persons died, 2 claim cases.
2 claim cases. Yes, record and order. Hey, applications to dekhi can 2. Learned advocates for the parties are present. This is an application filed by the applicant for amendment of the cause title. It is the contention of the applicant that the appellant Reliance General Insurance Company Limited has merged with in the Sindh UNDUSIAND General Insurance Company Limited. Thus, necessary amendment be made in the cause title. The certificate issued by Insurance Regulatory and Development Authority of India is also annexed in the instant application. In the facts and circumstances, This application stands allowed. Let the name of the appellant Reliance General Insurance Company Limited be deleted from the cause title and the name of the applicant in the Sindh General Insurance Company Limited be incorporated as appellant in its place and stayed. This application stands disposed. The amendment be carried out within 2 weeks. Let this matter appear after 2 weeks.
But in the meantime, informal paper books may be prepared. Like,
Achha,
the records
both 1 and 2.
both 1 and 2.
The informal paper books, the trial court records be called for.
I have no, my lord. I have the certified copies.
The informal paper books be prepared by the appellant within 3 weeks and copy be served. Liberty to mention after 3 weeks.
Kindly fixes a date. Kindly fixes a date.
Mention after 3 weeks.
This is pending since 2013.
Because I don't know whether she can file it within 3 weeks or not.
I'll ensure that it is.
Otherwise, you will take the
I'll
responsibility.
take
You
the
will file.
Yes.
Achha. The informal paper books be prepared by the respondents within a period of 3 weeks. Let this matter. Dekhun to. 20 August. 20th, 28, 2026 at 10:30 a.m.
Both the matters.
Yes.
I'm grateful, man.
My lord, I'm for the appellant. My lord, the appellant, to your lordship, is the mother, wife, and daughter. No. Son. Mother, son, wife of the deceased. My lord, the accident is a death claim, my lord, by client.
Quantum, you are challenging the quantum.
My lord, quantum only, my lord, in the one ground. That the, my lord, the deceased was a businessman of my lord, rice and my lord wheat. It was my lord stated by his mother. And my lord, the income tax, my lord, 3 consecutive years. My lord, income tax, my lord, ITR along with my lord, the documents were filed. ITO has come and proved. And in spite of that, my lord, the tribunal assessed the income of the deceased at 6,500.
How much?
1,500, that is 78,000. Instead of, my lord, 4,81,000. I shall, my lord, draw your loss. This is the first ground. Second ground is general damage, 70,000 giving, and it should be 84,000. These are the 2 grounds, my lord. Now, my lord, first, my lord, your lordship kindly, my lord, the evidence of the IQ. My lord, the PW1, the mother, PW3, eyewitness, the my lord, PW
Page?
Page 40. Page 40.
Yes.
This is on behalf of the Bangladesh, the Senate claimant, Bangladesh, the IQ has been summoned. Now, may I read the Bangladesh, the page 40. My name is Ranjan Kumar. My father's name is
Page 14.
Page 14 of my paper.
1-4.
1-4.
Yes.
I have been duly authorized by the IQ Bihun to depose in this case. Authorization letter dated so is March 14. I have bought the certified copy computer generated of IPS of the Sahil Mullah for assessment year of 2018 to 19, 2019 to 20, and 2021 and 21 to 22, which are marked as 18, 16, 4 years, my lord, the assessment record my lord, have been filed and marked as exhibit 15, 16, 17, 18. Now, my lord, the cross-examination. My lord, part is by the insurance company. I have not personally verified the income of the victim. Shohin Molla, the ITR of victim Shohin Molla is verified for the assessment year of 2018 and 19, and rest of years are presumptive as per declaration submitted by the victim. ITR victim is declared. Taxable limit is 2.5 lakhs, assessment year 2018. Above 2.5 lakhs, amount is taxable, and my lord, is not to be paid as per section 87 as subject for the assessment year of 2020, 21 and 22. I have no person involved. Now, my lord, these are the, my lord, these are the, my lord, the evidence of the ITO. Now, my lord, I shall draw your lordship attention. My lord, the accident took place is 16 June 2022. Before his death, my lord, your lordship kindly turn to page 121. That is the, my lord, the income tax return, my lord, ITR along with the documents, my lord, that is before the death he submitted. Your lordship got it on page 121.
Just a minute. Page 121.
Page 121. My lord, top at the, my lord, right hand side.
121.
121. Top at the, my lord, right hand side, assessment year of 2021-22.
Yes.
My lord, it is, my lord, the accident took place is 16/6/2022. Prior to date, my lord, this is the, my lord.
So this is deposited on?
This is deposited on. That is
16/6/2022.
Yes.
That is accident took place. And this income tax submitted when? Which date?
My lord, income tax submitted.
Your lordship will kindly come to page 128, Miller.
128.
Yes.
23rd November 2021.
23rd November.
21.
21. আর আমার শরীরটা
Yes.
Now, my lord, your lordship kindly turn to the relevant page is 125. My lord, your lordship, page, seeing my lord, page 125.
Yes.
My lord, the total income is, my lord, is 50, my lord, that is, my lord, the 1, 2, 3. Column number B. A, B, first one, and second is presumptive income under section 44 AD. That is, my lord, 4,81,003.
No, that is 8. Yes, presumptive income under.
Yes, 4,81,355. And my lord, total A plus B is 4,81,355. Now, my lord, next page is, my lord, that is page 126. Is that I need not go, my lord. ঠিক আছে, ready হয়ে আছে। That, my lord, my learned pen.
So 3 years returns were filed.
4 years.
Yes, that is 2020, that is 2021-22, then 2021,
1819, 1920, 2021, and 21-22.
Yes.
Now, the tribunal, disbelief, the not taking into consideration the income tax return on the ground that it is ITO's version is disbelief, as he says is a presumptive.
Where is that?
Findings.
Which page?
Page, your lordship kindly.
Where is the deposition? Let me see.
Deposition, I have said, I have placed there. Page 14.
Page 14. Where did he say that?
Cross-examination. I have not personally verified the income of the victim. The ITR of victim Sushil Mula is verified for the year 2018-19 and rest of the years are presumptive. As per
Where is the presumptive? This word used. I have no personal knowledge about ITR submitted by the victim. So, okay. This is verified and the rest of the years are presumptive.
Presumptive. As per declaration submitted by the ITR of the victim is prepared. My lord, kindly see the award of the tribunal.
Yes.
My lord, page 23. My lord, in the bottom portion.
Yes.
My lord, I am reading, my lord, from last paragraph in the, my lord, the middle portion. The petitioner filed ITR of the disease for the assessment year of 2018, 19, 19, 20, 21, 21. The income of the victim as shown is 5 lakh 43,000, 50,000. Income of the 5 lakh 4,300 for the assessment year of 2021, and the PW3, the income of the tax officer who deposed in favor of the petition. In his cross-examination, he categorically stated that he has not personally verified the income of the victim, Shulimullah. He further stated that ITR victim Shulimullah is verified for the assessment year of 2018-19. Rest of the years are presumptive. He further stated that as per declaration submitted by the victim, the ITR of the victim is prepared. So, from the evidence of PW3, it is crystal clear that ITR is prepared as per self-declaration submitted by the assessee. From the ITR, the actual income assessed cannot be from the ITR, the actual income of the assessee cannot be determined. Even nature of business also not mentioned in the ITR under such circumstances of the. Now, my lord, the nature of the business, my lord, your lordship kindly see the evidence of PW1, the mother, 5 to 9. PW1.
Yes.
My lord, kindly turn to my lord, paragraph 4, page 5.
Yes.
My lord, it was in chief, my lord, that my son expired due to motor vehicle accident, and at the time of accident, he was aged about 26. My son was a businessman and he dealt in rice. And wheat.
Anyway, it is not possible to say.
Yes, sir.
So how much will be monthly income?
Yes,
he may bring some money from the business.
Business.
Not possible to say.
That was not. My lord, your lordship.
Because you see, income are assessed at the end of the year.
Yes. My lord, your lordship, kindly, my lord, I am relying on the decision of your lordship, my lord, recent decisions. এটা একটু দেবেন? That income tax document is a statutory document. Your lordship, kindly see, my lord, page 5. relying on my lord the Kalpana Raj case, Malda Bhai's case, and the my lord, your lordship, kindly page 5. The income tax return is a statutory document on which reliance may be placed to determine the annual income of the RIS.
Page 5.
Page 5, last 3 lines. Where the Maladi Surinder Kumar Singh, Supra, Honorable Court, also held. আচ্ছা নে sorry my lord, your lordship delivered the judgment on December 9, 2025. Now my lord, no now my lord, another reported decision of our High Court is my lord Justice Vivash Patnaik. এটা একটু দেবেন সাহেবকে। That was reported in 2024 ACJ 201203.
This is unreported judgment, you see.
No, it is reported.
No.
Top.
Justice Patronax is reported. That Sundarani, that is not reported.
That will going to be reported. 2024 ACJ 203. Now, my lord, your lordship kindly turn to same judgment. My lord, his lordship, the Honorable Justice, relying the my lord, page 7. My lord, the second paragraph. The other challenge thrown to the acceptance of income tax return is that it does not pertain to the period of just proceeding. At this stage, it would be profitable to refer to the decision of the Honorable Supreme Court past series Kalpana Raj versus Tamil Nadu State Transfer, where the only available documentary evidence on record is the monthly income of the deceased, while the income tax return filed with the Income Tax Department and the Honorable Supreme Court in such circumstances. My lord, here also, my lord, his lordships relied on next page 8, Malabharaji and others versus United. Your lordship, my lord, in Shondarani's case also, my lord, relied on Malabharaji's case, where it was said that determination must record on the basis of income tax return where available. Income tax return is a statutory document on which reliance may be placed to determine the actual income of the deceased. I find substance in the submission made by Mr. Rai, learned advocate for the claimants, relying on the decision of the Supreme Court. Anjali, in this regard, from this aforesaid observation, the Honorable Supreme Court, it goes without saying that the income tax return being the statutory documents. Now, my lord, I am also relying the Anjali. Also, my lord, it is my lord, that was also reported Anjali, that is the Supreme Court decision. এটা একটু দেবেন জজ সাহেবকে। Your lordship, kindly turn to my lord, paragraph 9.
Yes.
The tribunal and High Court both committed gave error while establishing the disease income by disregarding the income tax return of the disease. The appellant had filed the income tax return in 2009 of the disease, which reflects the disease. The court in Mallavai's case has reaffirmed that income tax return is a statutory document on which reliance be placed where available for computation of annual income of art. So, my lord, the Supreme Court time and again says, my lord, that the income tax return which is submitted is a statutory document which reflects. My lord, এই আমি 4,81,000 এইটার উপর বেস করেই করেছি। দেখেছিস তো?
Extra paper আছেন দিচ্ছি জজকে দিচ্ছি Yes, this is what your calculation.
Yes, on the basis of 4,81,000.
4,81,000 is the annual income.
Is the annual income. That, my lord, I have placed the, my lord, that 2021-22 assessment year. Page 125. 4,81,000, future prospects 40%. Because my age of the disease is 25, the multiplier, my lord, and 40% future prospect, 1/3 deductions, use of multiplier 18, loss of constitution 40,000. And my lord, they have satisfied, my lord, the award before the tribunal. No cross appeal, no cross objection.
Yes, Mr. Singh.
As far as the income tax return is concerned, there is no dispute about that. That 481 figure, that is there. It was filed prior to the death of the deceased that I have shown to your lordship. Why the learned tribunal, is doubting that return, is the evidence of the income tax officer, which very specific, it says that it was, your lordship will kindly see, that is at page number 15, page 14. Lord has taken note of that note. It is presumptive.
Page 14.
Lordship. This is the evidence of the income tax officer. In the cross exam, my lord is there, page 14. In the cross examination, third line. And rest of years are presumptive. This presumption is because of the reason that there are, first of all, it has not been verified by the department. And secondly, there are no supporting documents with regard to the business, what has been alleged to be. Learned tribunal judge has taken note of this. In its wisdom, it said that in absence of any single document in support of the business, I'm not going to believe the income tax return because it may not, the source of income is not reflected anywhere. My lord, the income tax returns, are there, 4 years returns are there. In none of those 4 years return, the nature of business, the work, what he was doing, how he was, earning those money, nothing is there. Learned tribunal, in its award, it was read out to your lordship at page number 23. If your lordship kindly comes, once again to that. Page 23. Why, it disbelieved? Page 23, the fourth paragraph is starting with PW1 is stated. PW1 is stated in her claim petition that the victim was the businessman and he used to earn rupees 45,000 per month from his business. But the PW1 has not stated which business used to be run by her son. This is reflected and this is fortified from page number 1 of the claim application itself, which is there in the paper book. Page 1 of the paper book, No,
nature of business is not there.
Nothing is there, This is only business.
Nature of
column number 4.
Okay.
It's only business, nothing more, nothing less.
In the evidence?
In the evidence, at page number 10, page number 9, for the first time. This is also recorded by learned tribunal at page number 9.
Yes.
In cross examination, the 6th line from the bottom at the right side. In cross, my son used to run the business of rice and wheat. This is the only line.
Okay, and in a chief?
Lordship, can you say,
Chief
Lord
also
Chief?
pay.
Chief, what did he say?
Lord Chief, it starts at page number 5, Lord.
Paragraph 4.
This is the mother or the wife?
Mother.
Mother.
Page 5, paragraph 4. For the first time, Lord, in this evidence,
dealt in rice and wheat.
Lordship. Prior to that, there is nothing. And why I say, why it creates trouble, in the claim application and subsequently, at the time of filing of the documents, there is nothing. First time in the chief and in the cross, she said that yes, he was running a business of rice and wheat. And then, in the cross examination, if I read further from that particular line at page number 9, my son used to, my lord has taken note of, my son used to have the business of rice and wheat. My son was the supplier of rice and wheat. He did not run any other business. He used to purchase rice from different rice mill and also used to supply in different shop. At this moment, I cannot say whether bill for purchasing the rice challan are in my custody or not. And then the last sentence, Your Lordship will kindly take, I cannot file those documents later on. Nothing. And the difficulty is you don't file bill, you don't file challan, you give the trade license. It's not there. That has been taken note by the learned tribunal. You give the GST bills. GST is absolutely mandatory. You don't give that. Thereafter, the books of accounts, Milord, you are claiming that you are earning 5 lakh rupees per annum. The books of accounts, even those are not there. For all these 4 years for which, Milord, the returns have been filed, there is no trade license, there are no bills, there are no challans, there is no GST, and there is no books of account. Nothing is shown, Milord. It is only the business, and then the income is shown from the business. And that is why learned tribunal, in its wisdom, at page number 23, after taking note of everything, Milord, said that no, it is moreover the income tax officer also said that it is presumptive. So, Milord, your lordship, for once again, Milord, if my lord kindly comes to page 23, why learned tribunal came to this finding, Milord, I'll just indicate that.
Yes.
Page 23, Milord. PW1 has not stated which business used to be run by her son. In her examination in chief, stated that her son used to run the business of rice and wheat, and it is a new fact which has been incorporated in the examination in chief of PW1, and it is also beyond the pleadings. MSCT is civil in nature and is guided by civil procedure code. Beyond pleadings, any new fact cannot be taken into consideration. PW1, Milord, this is the line, could not produce any document in respect of business which the deceased used to run. Even the PW1 could not produce any trade license in respect of business of the victim. Even the PW1 could not adduce any corroborative evidence. Milord, nothing. That's what I said, Milord. No GST bill, no challans. And she said that she would not be able to produce also. Why? It is hardly been a, Milord, the last year the son has died. There must be some documents. Give the books of account. The trade license, Milord, is not there. Nothing is there. How come you claim, Milord, just 5 lakhs? Milord, the compensation they are claiming is, Milord, the calculation which was given to your lordship, 82 lakhs. Milord, for claiming 82 lakhs, Milord, one has to show certain documents and bona fide. It is not, Milord, 2 lakh, 5 lakh, 10 lakh, your lordship, Milord, that basis of global compensation or on the basis of notional income your lordship is giving. My lord is deciding the figure of 82 lakhs. And this 82 lakhs has to be, Milord, supported by the proper evidence. Filing of return may be illegal, we do not know what business he was running. What earning he was making? Was it in any, Milord, illegal supply of arms? I am not aware. I am not aware. Even today, Milord, he is not here with those bills or challans or the trade license or the GST. Milord, this quantum your lordship will kindly keep in mind, Milord. We are heading into crore with interest. Crore of rupees is a public money, Milord, is giving to somebody who cannot prove his business by any single piece of document. Milord, this is money, Milord, of each one of us. And we give it a crore of rupees to somebody who doesn't have any document to prove the income of the person concerned. This is what troubles me, Milord. Let him show, let him give the documents. I will not be arguing. This 481 I am accepting. Yes, he gave the income tax return, 481. And that is presumptive. That's what income tax officer says. He says it was deposited. It was reflected. Income tax returns were filed. But whether, Milord, whether it was genuine business or not, or whatever it was, Milord, that Milord, the lordship needs to take care of. Otherwise, Milord, everything else is in order. Return is there. I am not doubting the filing of the return. 481 figure is also there. The calculation is more or less other than, Milord, this consortium part, in which, Milord, he has paid for consortium for all three. The chart which was given to your lordship. Milord, the chart which was given to your lordship, Milord, other than consortium part, rest are okay. The calculation is also okay, Milord, correct. But, Milord, your lordship needs to be satisfied, Milord, that whether this business was genuine or not, and if not, then, Milord, that is why the reason, Milord, the learned tribunal in its wisdom, Milord, at the bottom of this page has considered, Milord, the notional income of 6,500.
That's
income
all.
is, Milord, that's all.
Yes, take down. Learned advocates for the parties are present. Are learned advocates. The appellants before this court was the claimants. The appellants before this court were claimants in a case under section 166 of the Motor Vehicles Act 1988 and is aggrieved by the judgment and award dated this 24th day of April 2025, passed by learned Additional District Judge, Fast Track Court, Shuri, Birbhum, in MAC case number 223 of 2022. Stop. The case of the claimants, appellants may be summed up thus. Next paragraph. On 16/6/2022, at about 12:30 hours, when victim Shahil Mola was proceeding towards Nagpur check post by riding his motorcycle WB46 capital H-3989, and when he reached near Tilora Moor, at that time one lorry being numbered WB93-0716 lorry dashed his motorcycle, and as a result the victim sustained serious injuries. Stop. The accident occurred due to rash and negligent driving by the driver of the said lorry bearing number WB93-0716 lorry, and the petitioners have suffered pecuniary and non-pecuniary losses. Stop. Pursuant to filing of this case, notice was issued upon the opposite parties. Stop. Opposite party vehicle owner did not appear and contest the case. The opposite party vehicle owner did not appear and contest the case. Stop. The opposite party insurance company contested the case by filing written statement and adducing evidence. Stop. Issues were framed and evidence was adduced. Stop. Learned trial judge, upon perusing the evidence and upon hearing the learned advocates for the parties, was pleased to dispose of the claim application by observing and directing as follows. Stop. এখান থেকে এটা ফোল্ড করে দিচ্ছি। The appellant, being aggrieved by the judgment and award passed by the learned trial court, has come up with the instant application. Stop. Third learned advocate for the appellant's claimants and learned advocate for respondent insurance company peruse the evidence adduced and materials on record. Learned advocate for the appellant submits that the learned trial judge erred in not considering ERRED in not considering the income tax return filed by the claimants with regard to the income of the victim and merely proceeding on the basis of notional income. Stop. Learned advocate further submits that the 4 years income tax return submitted by the victim was filed before the learned trial court, and necessary particulars were there which the learned trial court failed to consider. Learned advocate also submits that the annual income as per the income tax return is ₹4,81,355, which should be the basis for computing the compensation. Learned advocate relies upon the following judicial decisions. Number 1, Srimati Suchitra Ghosh and others versus National Insurance Company Limited and others. Reported in 2024 A capital C capital J 1203. Next, HON'BLE versus Lokendra Rathod, reported in 2023 ACJ 637 within bracket SC. Next, Kondha Rani Jana and another versus ICICI Lombard General Insurance Company Limited and another, FMA 70 of 2023 within High Court at Calcutta. learned advocate for the insurance company submits that necessary particulars with regard to the business of the victim was not submitted by the claimants, for which the learned trial judge disbelieved the income tax return submitted on behalf of the claimants. Learned advocate further submits that the deposition of the income tax authority goes to show that the victim, that ITR of victim Shahil Mullah is verified for the assessment year 2018 and 19, and rest of the years are presumptive, on the basis of which learned trial judge came to the conclusion. Stop. Learned advocate also submits that unless necessary particulars of the business and such as accounts and statements are furnished, the income of the victim cannot be decided, cannot be ascertained. This court has considered the submissions made by the learned advocates, the decision of the learned trial judge, and the decision relied upon by the learned advocates for the parties. It is held in different judicial pronouncements that income tax return is the authentic document on the basis of which motor accident claim tribunals can decide the income of a affected party and arrive at the compensation to be awarded. Stop. In the case of Anjali versus Lokendra Rathod, Supra, the Honorable Supreme Court observed as follows. Just set out para 9, folded page. ঠিক আছে? Yeah. In the case of Suchitra Ghosh and others versus National Insurance Company Limited and others, SUPRA, it was observed as follows. এখানে in the case of Shondha Rani Jana and another versus ICICI Lombard General Insurance Company Limited and another, SUPRA, it was observed as follows. এই যে ঠিক আছে, এখান থেকে এইটা আর এখান থেকে এইটা। Next. It is true that when income tax returns are not filed by any person, it becomes difficult to assess the income of the said person unless the said person is a government employee or employee of any undertaking from where the pay slips can be furnished. Stop. In the event a person is engaged in business and he does not file income tax return, it becomes necessary to furnish accounts or the bank passbook and the trade license. Stop. Stop. By filing the income tax return and paying necessary taxes goes to show that the income earned by a person is taxable. Hence, the income tax return being an authentic document, courts need not insist on furnishing necessary accounts or particulars with regard to business, especially when the matter relates to motor accident claim, which is a beneficial legislation. In usual practice, when businessmen furnishes income tax return, the necessary accounts are furnished before the income tax authority, which are taken into consideration by the income tax authority to assess the income. Stop. In the event the income tax authority disputes the income tax return, necessary notice are issued upon the assessee for clarification. In the instant case, the witness from the staff from the income tax department has stated that the income tax return for year 2018 and 19 is verified and the others are presumptive. Stop. By using the word presumptive does not mean that it is a fictitious document and no reliance can be placed on it. In all cases, when assessments are not complete, it has to be stated that the returns are not verified. As the income tax return are filed prior to the date of the victim, there is no scope for presumption that the income is inflated for the purpose of any material gain. Thus, upon perusing the observation of the learned trial judge and considering the documents filed and the evidence adduced, this court is of the view that these are sufficient for the court dealing with motor accident claim cases to ascertain the compensation on the basis of the income tax return. Thus, this court is of the view that the judgment that the compensation awarded by the learned trial court should be enhanced. In the event the annual income as per the income tax return is considered as rupees 4,81,355, the future prospect of 40%, which comes to rupees 1,92,000, is added. The total income comes to rupees 6,63,897. 1/3 being deducted on account of personal expenses, the net total income comes to rupees 4,49,265, which is the annual dependency loss. Stop. The multiplier of 18 being applied, the total dependency loss comes to rupees 80,86,770. Here consortium is what? Parents and wife.
Mother, son,
then 80. The further, the claimants are entitled to compensation of rupees 1,10,000 on account of loss of estate, loss of consortium, and funeral expenses. Thus, 81 lakh 96,770 is the total compensation which the claimants are entitled as per arithmetical calculation. Stop. However, as courts and tribunals are empowered to award just compensation as per section 168 of the Motor Vehicles Act 1988, it is necessary to consider a judicial decision in this regard. Stop. In the case of Anjali versus Lokendra Rathod, Supra, the Honorable Supreme Court observed as follows. এইখানটা লিখে দেবেন, হ্যাঁ, প্যারাগ্রাফ 10 থেকে। Stop. Thus, the compensation in motor accident claims cannot be a bonanza or a meager compensation. Hence, this court is of the view that although by arithmetical computation, the total compensation comes to rupees 81,96,770, but compensation of rupees 75 lakh is just and reasonable. Stop. Hence, the appellants claimants are entitled to compensation of rupees 75 lakh from the respondent number 1 insurance company, along with interest at the rate of 6% per annum from the date of filing claim case till today. The appellant in the respondent number 1 insurance company shall deposit before the Registrar General High Court, Calcutta, rupees 75 lakh, along with interest at the rate of 6% per annum within 3 months.
Less the awarded amount.
Within 3 months from the date of communication of this order. Stop. In the event compensation awarded by the learned trial court is already deposited or paid, the balance amount be deposited. The claimant's appellant will be entitled to withdraw the compensation upon compliance of necessary formalities.
Obliged to my lord.
Yes.
I'm grateful to you.
ওগুলো দিয়ে দেবেন সবগুলো জাজমেন্টের এগুলো, হ্যাঁ, জাজমেন্ট গুলো, হ্যাঁ।
I am for the appellant, man. This is my
54.
section 5 application. Copy was served long back 1 year, and last 3 occasion or 4 occasion the respondent took time, my lord. Matter was fixed, but that was not hard. This is
Can 2.
can 1 is, my lord, application for section 5, my lord.
Can 1 is not appearing in the list. Item 54.
64, my lord.
64.
53 days delay, my lord.
Okay.
53 days delay.
Okay, can 1.
Can 1. অনেকদিন হয়ে গেছে। Actually, what happened, my lord, when I applied for certified copy, the concerned clerk only supplied my judgment, not decree. That was delayed. To pay for appeal, 53 days delay occurred.
So date of decree is 30th of April 2024.
24.
When did you obtain the certified copy?
Well, I have stated, my lord, that is the paragraph 12. And also, my lord, after receiving paragraph 10, that the plaintiff, after receiving the certified copy of the said degree, your petitioner immediately on 5th September contacted the lawyer and ultimately landed lawyer.
Section 5 consented. Need not to be.
So why I have to see your face after such a long period? Why didn't you show your face for the last few months?
But in other courts.
How many days delay?
53 days.
53 days. Yes, record an order.
Now I have to go to the order 41 bench, my lord. For
Because it
admission.
is not proper to pass order in your absence.
No. My junior is there. I have also
I never
Learned-
opposed, my lord. Every occasion I consented.
Learned advocates for the parties are present. Hard learned advocates. This is an application under Section 5 of the Limitation Act filed by the appellant with a prayer for condoning the delay in preferring the appeal, which is about 53 days. Upon perusing the petition and upon hearing the learned advocates, it appears that the appellant could not get the entire copy of the decree for the purpose of preferring this appeal. Thus, there is a delay in filing this appeal. Upon hearing the learned advocates, this court is of the view that in the interest of justice, this application should be allowed. Thus, I allow the prayer of the appellant for condoning the delay. The delay in preferring this appeal is condoned. The application can 1 of 2024 stands disposed. Let this matter be placed before the Honorable Division Bench, having determination in the matter for the purpose of admission.
And appeal is registered accordingly.
Yes, accordingly. After admission, it will be registered.
হ্যাঁ বলুন নাম দিয়েছে তো
So application is allowed.
Application was allowed.
Can 2 is allowed.
Allowed.
Okay. Amendment carried out.
Amendment হয়েছে দেখুন।
Just a minute. Achha, let the 2 p.m. fixed matters be called first. 2 p.m. fixed matters গুলো এটা 2 p.m. এ ছিল কি না যেটা লিস্টে রান করছে আর কি
Madam, this was fixed today only.
Oh.
It got missed.
Correction has been,
Yes. Yes. Yes, what are the grounds of challenge?
my lord, the grounds of challenge is mainly that contributory negligence and quantum income of the deceased. My lord, the claimant respondent was traveling by a motorcycle wherein this offending vehicle, as alleged, is a truck which dashed the motor vehicle, as has been alleged. The deceased was not wearing a helmet. My lord, we come to
Yes.
for the fact of the case, my lord, paragraph 1 and 1 of the judgment, page 19 of the paper book.
Yes.
The petitioners are the parents of the deceased. Petitioners, namely Joyade and Gautam, they have approached this tribunal for compensation for accidental death of their son, namely Vivek De, for an amount of rupees 50 lakhs. Deceased Vivek De died in a road traffic accident by the offending vehicle bearing registration number such and such on 18/12/2020 at around 11:30 p.m. The deceased was returning home to his house at Baneshwar More under Bhaktinagar police station from his place of business at Pradhan Nagar through his motorcycle bearing registration number such and such through the left side of the Ishkon Temple Road. When he reached near Annapurna TVS stockyard, at the time of the offending vehicle bearing number such and such dashed him. The victim sustained severe injuries on his person and he was taken to Anandalok Hospital Private Limited, Siliguri, where he expired on 23/12/2020. According to the petitioners, the accident was taken place due to rash and negligent driving of the offending vehicle bearing registration number such and such by its driver. Then the postmortem. This is the fact of the case. Now, my lord, let us come to the FIR. FIR was lodged by the claimant, father of the deceased. Page 36 of the paper book. My lord have got it?
Page 36.
Page 36.
Yes.
This is the written FIR which was lodged by the father, I Gautam De, or that on 18/12/2020 at about 11:30 p.m. Again, the whole story has been given that my son, paragraph 3, that my son sustained serious head injury. Paragraph 3 of the FIR and other severe bodily injuries and is presently under ventilation at Anandalok multi-specialty hospital of Siliguri, fighting for his life.
That means prior to death, FIR was lodged.
Yes, yes. On 22/12/2020, FIR was lodged. On 23/12, he died. Now, my
And the date of accident, 18/12.
18/12. Now, my lord, kindly come to page 38, the charge sheet.
Yes. Yes, page 38.
38, my lord, property description, which the things which has been seized. Number 2, my lord, fitness certificate of vehicle number, the offending vehicle was valid up to 27/8/2020. 8/2020. And the accident occurred on 18/12/2020. So CF is failed, my lord.
Witness certificate not valid.
Then number 6, my lord. After 2, in the
Yes.
same page, number 6, pollution certificate valid till 26/2021. 2021. Okay, it is valid. My lord, then please come to page 40. My lord, have got it.
Yes.
In bold, my lord, it is written collected mechanical report, my lord. Then
Yes. Collected PM report.
mechanical report,
Where? Yes. Collected mechanical report.
time of examination, and then made over this to ICBK and PS to be transferred from the PS. Later on 1/1/2021 as endorsement, ICBK and PS1 took up its investigation. In course of investigation, as per order of the learned court, I have submitted report regarding no objection to release the vehicle to its owner. Examined witnesses recorded their statement under section 161 of CRPC. As per order of the learned court, release the seized vehicle with documents except DL to the owner under proper Zimmanama. Collected PM report, inquest and dead body challan from the investigating officer Mijanur Rahman, UD case number such and such. And then, my lord, opined that the cause of death is due to the effect of head injuries. My investigator has investigated the case and seen that he did not wear a helmet. During investigation from the evidences and other materials, it is crystal clear that on 18/12/2020 at 23 hours, accident driver Nimai Bormon driving his vehicle such and such is a rash and negligent manner and dashed one motorcycle bearing number such and such, being driven by Vivek De. Vivek De sustained head injury and got admitted into Anandolok Hospital, wherein Vivek succumbed to his injury on 23/12/2020. So prima facie charge is has been well established against the accused driver Nimai Bormon. Hence, in consultation with my superior, I am submitting the charge sheet against the said driver. My lord, please come to page 45.
Yes.
Certificate of registration. And then the fitness up to 1, 2, 3, 4, 5, 6, 7th line, my lord. 27 August 2019 to 11 July 2019.
This is the fitness certificate of the vehicle.
My lord.
No, this is the vehicle.
This
is the certificate of registration. Certificate of fitness. Which page?
47.
47. Yes.
Certificate will expire on 27th August 2020 And next inspection due date on 29 June 2020. Then, my lord, please come to page 53, the post-mortem report.
Page 57.
53, 53.
53. Yes.
My lord, I've got it.
Yes.
Remarks by civil surgeon at the right-hand corner. Death was due to the effects of antemortem head injuries, as noted above. It was a head-on collision. He was not wearing a helmet, and there was some type of contributory negligence on part of the driver. I mean, the victim. At least 20%. My lord, I do not have the judgment of Khenai. I will give it to my lord's court officer tomorrow. Khenai,
That is with regard to composite negligence.
contributory and composite negligence. That has been discussed in Khenai, my lord. Very elaborately.
Yes. Any other points?
Yes, my lord. Regarding the income, let us come to the page 12. The deposition of PW1, the father of the deceased. Paragraph 6.
Yes.
At the time of accidental death of my deceased son, namely Vivek De, was aged about 29 years, and he was an employee of commercial industries, multi-color offset printers of Shiliguri branch, and had self-business at Pradhan Nagar, Shiliguri. My son was an income tax payee, and as per income tax return, his yearly income was rupees 3,71,879. Well, let us now come to page 57. The income tax returns.
Yes.
15, 16. Read the accounts. Not verified.
No, this was exhibited.
Exhibited, my lord, exhibited. 16, 17, IT, page 61. Some computation of income has been given without verification. And 17, 18. Also without verification.
No, income tax return was exhibited
My lord.
by with this witness, income tax authority.
But what he has said in his cross.
It is not possible for a father to know everything of the son's income. Whatever is there in the record, you have to go by that.
Yes, my lord. But we have to see what the apex court have said.
Yes, yes. Income tax return, we have to go by the documents. In oral evidence, many things can be said.
And he has said that he used to work under some printers. Huh? Commercial industries, and nobody came from there to depose. No appointment letter was given.
He has earned something,
My
not
lord.
that whether he worked at X or Y, his earning was there.
He worked at X, Y, Z, but
Maybe.
nobody came. He didn't.
Nothing, that is immaterial. How much he earned, that is material. Suppose he did not file the income tax return. In that case, yes, employer's certificate is necessary.
Now let us see the Apex Court judgment passed on 1st July 2026. Judgment term. Ramidekha Tripathi versus Sriram.
Yes.
Poila July 30. My lord, please come to page 5.
Page?
From page 3, my lord, from paragraph 7 of the judgment.
Page 3.
Page 3.
Okay, of the judgment.
My lord, have got it?
Yes.
Aggrieved thereof, respondent number 2, the insurance company filed
So
in
page 3, running page 21.
page 3 of the judgment, my lord.
Oh, this Supreme Court judgment. Yes.
Aggrieved thereof, respondent number 2, the insurance company filed an appeal before the High Court seeking reduction in compensation awarded by the tribunal. It was submitted therein that the tribunal erred in computing the income of the deceased and applied the wrong multiplier, as the age of the deceased was 39 as per his PAN card. The High Court, vide the impugned judgment, allowed the appeal and reduced the compensation awarded by an amount of rupees 9,24,914 to rupees 1,87,150 along with 6% interest per annum. The court reduced his annual income as rupees 13,33,226. For this purpose, the court took the average of previous 2 ITRs which were on record instead of only previous ITR which was taken into consideration by the tribunal. Furthermore, the court applied a multiplier of 15. Dissatisfied, the claimant appellants are now before us. The significant ground of challenge taken is that the courts below have erred in assessing income of the deceased. We have heard the learned counsel for the parties. The issue which arises before this court is whether for assessing annual income of the deceased person or claimant under the Motor Vehicles Act 1988, the ITRs for the previous year is appropriate or average of the past 2 or 3 years is to be taken into consideration. In view of importance of the issue involved by the order dated such and such, this court appointed Mr. J.R. Midha, learned senior counsel, and Mr. Salil Pal, learned counsel, as amicus curiae, both experts in this field, to assist in this matter. Mr. J.R. Midha, learned senior counsel, has submitted that there is no uniformity in the principles relating to the computation of annual income on the basis of ITRs. Some courts take average of the last 3 years, whereas some courts take the last return filed to assess the income of the deceased. He further submitted that while the ITR is the prima facie evidence of the deceased's income, it does not always reflect the true income of the deceased. Factors such as business income pattern, growth pattern, and nature of business also warrant consideration. Moreover, in cases where the ITR has been filed after death, it would be appropriate to call for the ITRs for the past 3 years along with balance sheets of the concerned person or entity. Mr. Salil Pal, learned amicus curiae, has submitted that his court in ICICI Lombard General Insurance Company Limited versus Ajay Kumar Mohanty and another relied upon the average income of the ITRs for the previous 3 years to compute the income of the claimant therein. At the outset, we must reiterate that it is settled law that the objective behind the claim process in the Motor Vehicles Act 1988 is to grant just and fair compensation. Recently, a two-judge bench of this court in V. Padmavati and others versus Bharti AXA General Insurance Company Limited has succinctly summarized this position and observed, we ought to remind ourselves at the outset that when an individual dies as a result of fatal road accident and his distressed dependents apply for compensation either from the owner of the vehicle responsible for death or insurance company with whom such vehicle is insured, no amount of money can truly compensate for the loss. Compensation is nothing but rough estimate being a token amount to ease financial burden on the dependents. Take consortium. For example, it is impossible to put a price on the loss of loved one's companionship, spousal, filial, or parental. Compensation is all about acknowledging the emotional void, but the payout can never be more than a rough approximation. It is like trying to measure the immeasurable, considering the income of the deceased, the needs of his dependents, and the emotional toll of the loss. The best that can be ensured is that the compensation is fair and reasonable without being either arbitrary or niggardly. This would be in accord with the fundamental principle governing determination of just compensation under Section 168 of the Act. My lord, then the Reshma Kumari has been
Yes.
versus Madan Mohan has been discussed.
Yes, in earlier case, you have cited this decision.
Yes, my lord, but here I want to come to
In this case, the income tax return is filed after the death or before the death.
paragraph 19 of this
For 5 years.
paragraph 19 of the judgment, my lord, kindly. When it comes to self-employed or individuals carrying out their own business, in our view, the average income of specified in the ITRs of the previous 3 years is to be taken reference point for assessment of annual income from their business. There may also be a scenario where only 1, 2, or 3 ITRs have been filed. Given such scenarios and fluctuation of income in these professions, surrounding circumstances are also to be taken into consideration. This would include the nature of business, including geographic location category, growth pattern of the business, and impact of death on the business. Potential growth of the business, for instance, certain business are capital intensive at the outset and are profitable at scale in the future. Negative income, certain businesses may require losses in the initial years, which may not reflect the true financial standing. Any other relevant factor of the businesses. These are to be taken into consideration.
Yes, on these arguments are to be made before the trial court on these points. Then only the court can consider the factors. Arguments are to be made.
My lord, the arguments were made that
With regard to the business, that this business may survive.
That this income cannot be taken into
Not income, regarding the nature of business, you see. The observation of the Supreme Court with regard to nature of business. So these arguments are to be advanced before the trial court. Considering the nature of the business, the chance of profit and loss.
Only filing of the ITRs without, and also no employment letter from the office of where he received salary. Nobody came before the tribunal to adduce evidence that he used to work in commercial industries. So this type of income cannot be taken. And another is contributory negligence, and that he was not wearing a helmet. And my lord,
Any authorities on that, with regard to helmet, contributory negligence?
my lord, this court in one of my cases given
Or a Supreme Court decision
in a
with
court,
regard to this helmet?
he was not wearing helmet, Justice Dipankar Datta.
So here
I have that judgment. I can forward it to my lord.
question is,
Sir.
this point was argued that helmet was not owned by this thing. Anything in the evidence?
No, my lord. Only the head injuries everywhere we have seen. That is why.
Very well, but the
further this argument.
question is
My lord,
any evidence by the insurance company?
Only pay and recover because of the fitness certificate which I have shown to your lordship.
So the
Contributory negligence to the point of 20% at least. And the evidence in regard to
how much is awarded?
award
38 lakhs.
30, what?
38 lakhs, 8200, 520.
80, yes, 38 lakhs 82,520 along with interest, man. We have deposited. And the claim, the parents are the claimants, my lord. It cannot be a bonanza. Has to be just and fair compensation. Otherwise, they will always go on without wearing the helmet. My lord also knows how they
No,
drive
question is,
the motor vehicles.
question is whether you see any evidence is adduced by the insurance company. That is what I was asking regarding helmet, because investigator has caused inquiry that this person was not wearing helmet.
No evidence adduced.
That is the thing. And another thing is fitness certificate. So is a violation of the policy. So let us see your policy regarding fitness.
Since papers were not in order. And also, my lord, see, last এটা কত number deed of partnership which has been exhibited as কত number exhibited? Exhibit 13 with objection, my lord. Exhibit 13, page 90 of the paper book. Nobody came before, means the partner did not come before the tribunal to say, yes, this business was his. And this is a notarized partnership deed. My lord, kindly see. Page 90.
Yes.
Vivek Dev was partner of Sudipto Saha, and he did not come before the court. And this is a notarized partnership deed. And on the basis of that, they are getting so much of compensation.
That's all. Yes.
I'm grateful.
So far as my learned friends first submission, negligence, contributing negligence or composite negligence. Nothing was adduced before the learned tribunal. No plea was taken.
Plea was taken. Yeah, written statement.
No evidence was adduced.
It was a head-on collision or dashing from behind. It is head-on collision or dashing from behind.
Head-on collision,
Head-on collision.
not behind.
Head-on collision.
Yes.
And that without a helmet, I have a judgment in my favor of this,
Okay, give it.
of a coordinator.
But the question is whether evidence was adduced that he was without helmet.
So far as the
That is the question.
helmet. No
Anyway.
no findings is there. No averment is there. Nothing raised before this learned tribunal. So
Only thing, this is head-on collision.
head-on collision. As a man, Lord, got injuries in his head, does not mean that he did not wear a helmet. Even if the helmet is not there, that does not mean his negligence itself. So, Lord, on this point, Lord, learned friends, Lord, raising, Lord, frivolous claim here. And so far as the income is concerned, income tax return filed for 5 to 6 years. Return file, Lord, starting from 15, 16, 16, 17, 17, 18, 18, 19, and 19, 20, 21. On return file after the death, before the end of the assessment year, he died. So he did not got an opportunity to file this return.
No, actually, the court proceeded on the basis of average income or last income?
Last income.
Okay.
Last income file after death. That was not considered.
No.
That was not taken.
That was not taken.
No.
But prior to death, that income was taken.
Which has to be taken, my lord, and this
No.
salary.
Now the question is, if the income tax return is filed after the death, okay,
that is not been taken.
That can be ignored. And what is filed prior to death, that can be considered.
That is considered.
So prior to death, the last income is considered last year.
My lord.
My lord, the average has to be taken.
No, there are different views. Okay.
But if you also take it that my last year's income after death, that is that no inconsistency is there. A consistent income tax return or increase of income is there. So no inconsistency or no unnatural something is there. That has not been taken by learned tribunal. That ought to be taken. But I have not taken. I have not filed my cross objection. So I am not paying on that. But learned tribunal rightly taken the income of the previous year, the last return. But his income was gradually increasing in every year. And Lalaj also found it. So there's nothing, Lord, to disbelieve the income of the Lord deceased. His income from business of trading. So the constituency increase his business. So Lord, I submit, Lord, no ground is there in the Lord appeal in any respect. No ground is valid.
Yes, record an order. Learned advocates for the parties are present. Have learned advocates. Hearing is concluded. Let this matter appear for judgment on 11/8/2026. Actually, you can supply that judgment, whatever you want to rely tomorrow.
I'm grateful.
আমি লিখে দিচ্ছি।
Supplementary list.
Yes, item 5.
No, I'm for the application.
আচ্ছা এখানে ধরতে একশো কোথাও দাঁড়াই না দাঁড়িয়েছিলাম 28 ঢুকে গেছি
দাঁড়িয়ে আছিস কেন?
28
সরে যাচ্ছে।
This is a injury claim.
Item 4 ডাকলেন না?
Item 4 কেন রাখবো? আছি তো 4 হয়ে গেছে। Item
458 should be active as PS 485.
কে দিছে এটা
बोल मेंशन करो आइटम 4 में टाइम लेना है। बोल दो ना, किसको बोलो? हमको बोलो, आके बोल दो।
Yes, what is the ground of challenge?
Yes, ground of challenge is Malat.
চারের সময় নেই তাহলে তো বলে দিন সময় ফিক্স করে দিতে।
I
item 4, it was before this item 4 was there, fixed at 12 noon.
Both parties were present.
Yes, my lord, he is for the appellant. He wants, my lord, let the matter be adjourned because certain more documents are to be added.
Position of witness and affidavit in chief has not been annexed.
So affidavit, okay. Item 4.
You made the application.
Learned advocates for the parties are present. On the prayer of learned advocate for the appellant that he intends to file a supplementary paper book, the matter stands adjourned till 18/8/2026 at 3 p.m.
For filing of supplementary paper.
Anyway, for hearing.
My lord, this appeal is, my lord, for the enhancement of the award passed by the tribunal on the, my lord, 3 on 4 grounds. First ground is that no future prospect has been considered by the tribunal. First, your lordship kindly note it. 40% future prospect is to be assessed. My first ground is that no future prospect has been granted by the tribunal while passing the award towards the mother victim injured. Future prospect. Second ground is that mother disability 80% to 100%.
Yes.
In the case of amputation, my lord, right leg was, my lord, amputed above knee, and my lord, the disability board and doctor says, my lord, 80%, but my lord, the settled principle by the Honorable Apex Courts, I have got a very recent decision that it may be 100%. A person, my lord, who was working before accident, if after accident, if he cannot, my lord, return to his, my lord, that position, it amounts to, my lord, 100%. That is the, my lord, the Pratap Narayan Singh Dev, your
How
lordship,
how much the learned trial judge take into consideration? Percentage of disability?
80%.
80%.
80%.
As per the disability certificate, it is 80%.
80%. But my lord, in doctors,
What was the occupation of this person?
carpenter.
Okay.
Now, my lord, my third ground is that the income has been assessed as, my lord, 6,000 instead of, my lord, 9,000. Though, my lord, the employer has come and deposed and salary register was produced, that he used to earn rupees, my lord, 9,000. My lord, that was the
Carpenter, that means employee of the
employee of, he was working in a, my lord, in a furniture
shop.
Furniture shop. And the proprietor of that shop has come and deposed. And my lord, the fourth ground is that inadequate compensation, that is loss of amenities, pain and suffering, say 20,000, my lord, 10,000.
Total awarded how much?
Total awarded is 13 lakh.
13.
On the basis of, my lord, 7,000. Now, my lord, the accident took place in the year 2018. Often the vehicle he was struck. My lord, first, my lord, I shall, my lord, place the, my lord, the evidence of PW1. That is, my lord, the page 38 to 65. Now, page 10 to 13. My lord, kindly turn to page 11. Paragraph 8 of my paper book.
Paragraph 8. Yes.
Paragraph 8, page 11. That I was a carpenter by profession. I used to work under the Basudev Dolui. I used to earn rupees 9,000 per month. And the, my lord, the cross-examination, there is no outcome that his income is less than, my lord, 9,000. My lord, your lordship, kindly turn to page 13, the cross-examination portion on behalf of insurance company. My lord, he said that I do not have any document to prove that I used to earn rupees 9,000 per month as carpenter. I have filed documents to prove my right foot got amputated due to the accident.
What is his age, this person's?
Age of the person is, my lord, is 31 years. My lord, I have no dispute regarding the application of multiplier. 31, my lord, 16 multiplier applied. Yes. Now, my lord, your lordship, kindly turn to PW5. He is the, my lord, the proprietor of the Marti Furniture. Page 19.
Page 19.
19.
Yes. Yes.
My lord, kindly allow me to read, my lord. Chief, I am Samun Witness. I am a carpenter by profession. I have brought the original register showing employment of Rajkumar Das with Matri Furniture. This is the attested copy of the duly attested by me. The attested copy of the employment register is compared with the original and finding of the same identical person as marked Exhibit 9. He was drawing rupees 12,000 per month. He was receiving his salary by putting his signature on the salary register. I can identify his signature as he was a co-employee. The signature is appearing as serial number 3, Rajkumar Das. I am proprietor of Matri Furniture and I have license to this effect. The copy of the license is marked Exhibit 10. Now cross-examination. It is true that I issue certificate in favor of Rajkumar Das which bears my signature. I issue certificate on earth, but the Xerox copy does not bear the date. The certificate dated so and so is mentioned that this is Rajkumar Das was getting rupees 9,000 per month. Voucher he was getting rupees 3,000 per month for fooding. There were 6 persons including me in my furniture house. I pay about 60,000 to my employees per month. I find ITR. I pay rupees 12 lakh as income tax to the government. I do not show the entire images of this one. That non-production of my ITR by the employer does not mean that he did not. Apart from that, the accident took place, my lord, in 2015. And a skilled persons, my lord, like carpenter, my lord, 2018, sorry. A carpenter can easily earn rupees 300, my lord, per day.
What is the wages as per minimum wages act, carpenter? Although you see employer has deposed, but what is the wages?
8,000 to 10,000.
8,000.
My lord, I have a, my lord,
Very
I
well.
have a
Go to
judge.
that skilled person.
Skilled person. My lord, before that, my lord, I placed the one documents, that is the salary register. At page, my lord, 203 to 233.
Yes.
My lord, your lordship is seeing 203.
Yes.
Now, my lord, the Kormi Talika. This is the wage register, my lord, the salary register. My lord, 1, 2, 3. 9,000. Rajkumar Das. And that was marked exhibit, my lord, 18. Exhibit 9. Without any objection. And my lord, it was reflected from the evidence of the PW5. Basudev Dulu.
Evidence of PW5.
PW5.
That is the employer.
That is the employer. And also he was a, my lord, the carpenter, he is a co-employee. Now, my lord, your lordship kindly turn to the disability certificate, page 70 to 71. Kindly see the, my lord, the picture.
71.
70.
Yes.
Rajkumar Das, aged about 31 years. this manner, this is the disability certificate issued by the Mednapur principal of Mednapur Medical College and Hospital, Paschim Mednapur. My lord, is say above knee amputation 80%. So in figures 80%, in was 80%. Now, my lord, PW3, এটা একটু বের করে দিতে বলো না।
Yes.
My lord, PW3, page 16. My lord, after the accident, he was to my lord Mednipur Medical College Hospital. Thereafter, he local my lord, the subdivision hospital. Then my lord Mednipur Medical College Hospital. Thereafter, he was my lord brought to the my lord the Bhubaneswar Medical Superintendent High Tech Medical College Hospital, Bhubaneswar. Page 16, your lordship seeing.
Yes.
I am summoned witness. I have been authorized by medical superintendent so and so. I have brought the summon record, including medical papers. These are summary slip, medical bills. Patient Rajkumar. The patient was admitted on 4/5/2018 and he was discharged on 13. Malad, it was wrongly written 13/5/2018. The medical bills of rupees 96,000. Patient was again admitted on 37/2018 and he was discharged on 1/8/2018. The total bill of rupees 17,000, so and so, so and so. Now, my lord, the learned tribunal judge kindly the assessment portion. My lord, page 9, page 29, the judgment. My lord, may I read, my lord, paragraph 1, 2, 3, 4, 5. From my lord, from top to my lord. As per deposition of PW5, injured Sri Rajkumar Das was employed with Matri Furniture and was drawing rupees 12,000 per month. Whereas, as per claim petition, the injured was getting 9,000 per month as salary from proprietor Basudev Dului PW5. In his cross-examination, admitted that in his certificate dated at so and so, it was mentioned that Rajkumar Das was getting 9,000 per month. It is also admitted that he was not being shown entire wages of employee in his ITR. The deposition of PW5 is not convincing one. The income of the Indian Rajkumar Das is not proved. Exhibit 9 is not admissible in evidence. Hence, notional income was to this. My lord, may I put a question to my lord? My lord, the employer who does not show, who does not produce his income tax, but he has came. Generally after accident, after is terminated, generally employer does not come. In spite of that, the employer has come and produced some documents where it appears that Rajkumar Das used to get rupees 9,000. But the learned tribunals, my lord, observed that since he was not producing the income tax ITR files and so and so, so and so, so income of Rajkumar Das cannot be believed. It can be notionally income as 7,000. He's a family person, my lord. He's a 31 years young boy. And my lord, your lordship, kindly consider his disability. The above knee, my lord, his right leg was amputated. A person, my lord, whose leg was amputated from his above knee, who was by profession carpenter, cannot be, my lord, work as a carpenter. My lord, in support of that, my lord, I place my lord, the remarkable judgment of my lord, it's a reported decision, Pratap Narayan Singh. It was reported in the long ago, 1976. A carpenter who lost his, my lord, right hand from his shoulder. My lord, the statute says 50%. But considering the, my lord, considering the functional disability, a carpenter cannot do his carpentry work after his, my lord, losing, my lord, limb from his shoulder. My lord, your lordship, kindly turn to
Yes.
my lord, kindly turn to, my lord, page C at last bottom paragraph. The commissioner held in his order dated so and so that the injury held resulted in the amputation of left arm respondent above the blow. He held further that the respondent was a carpenter by profession and by lost his left hand above the blow. He was evidently being rendered unfit for the work of carpenter, as the work of carpentry cannot be done by one hand only. He therefore adjudged him to have lost 100% of his earning capacity. My contention is that, my lord, a carpenter who lost his, my lord, right hand above cannot work as carpenter. My lord, that was, my lord, the judgment. My lord, one unreported decision, although, my lord, I shall place him, that a Khalashi, my lord, who lost his, my lord, leg.
This is Rajkumar Das.
Rajkumar Das.
This case? Oh, this
My
case.
lord,
Anyway, this is the same name. Name is same. This case and the decisions relied upon.
Rajkumar Das, my lord, here.
So here also it's one Rajkumar Das.
Rajkumar Das. Here the medical board assess 60%, but the court consider 100%. Relying, my lord, kindly turn to page 5.
The carpenter.
He was a Khalashi. Khalashi lost
Khalashi
his.
is one thing, carpenter is another thing.
Yes.
Khalashi, either hand, leg, both are vital.
Khalashi, my lord,
Carpenter may not be so. And in this case, Supreme Court, it is hand, not leg.
My lord, your lordship, kindly see the latest Supreme Court judgment. I'm handing over my report. Here income was assessed as 9,000. I raise.
No, not income, percentage of disability.
Percentage of disability. Your lordship, kindly turn to my lord. My lord, page 22. It was also a case of amputation, my lord. Carpenter. My lord, may I read, my lord? It was এটা একটু দেখবে। ওই কার্পেন্টারের হচ্ছে 9,000 টাকা ধরছে আর 100% ধরেছে 70%। It was added that to earn his bread, he had to work by loading, unloading vegetable into the pickle, which was the only avocation he was carrying. Now, by virtue of amputation of his leg below knee, appellant is not only unable to work as a loader, but even unable to stand without support. As such, the functional requisites to be considered at 100% and not 70%. The appellant claimant in the present case, in Shankar Datta, was engaged in a carpentry work. His right leg, lower half part was amputated. Now, kindly turn to the assessment portion. Now, kindly turn to page 28.
Yes.
In the yearly income to be assessed on the basis of monthly income of 9,040. 9,000, my lord, assess.
Accident 2004 সালে।
My lord, here the accident took place in 2004.
প্রথমে লেখা আছে।
My lord, page 11, a carpentry skill worker.
Carpenter is a skilled worker.
Yeah.
Anyway, when employer does not depose, then that becomes essential. So how much is the minimum wages?
Minimum
8,000 to 9,000.
8,000 to 9,000.
No, this is the incident of 2016.
2018.
18. And what was the minimum wages?
Minimum wages. I am giving the printout copy. That is 9,000 to 10,000. Shankar Datta, I have handed over the case. Here, it was very recent decision. It is decided on 24 June 2026, where the carpenter lost his leg above knee. The tribunal
This
assessed
is carpenter.
Carpenter.
This Shankar Datta.
Shankar Datta.
That is page.
কি দেখতে আছেন? কোনটা?
Page 28.
28. Oh, cost and maintenance of artificial leg. That is the thing.
Page, cost of artificial legs is another matter.
That is one thing.
Paragraph 6. In the yearly income to be assessed on the basis of monthly income of rupees 9,000.
Yes.
Here the accident took place in the year 2004.
Okay, very well. So future prospect is 40%.
40%.
So that is 1,50,1,200.
Kindly see the minimum wages. এই রেটটা একটু দিন তো জজকে। My lord, here the accident took place 2018. My lord, monthly minimum wages for a skilled worker such as carpenter. West Bengal on the establishment at 9,000 for Zone A.
And 8,713 for Zone B.
Zone B.
জোন এটা হলো কি তোমার ইয়ে
দেখি
9,400 এত আর 8,701 কত দেখাচ্ছে? এটা তো এই 2000 in July 2018. Zone A, my lord, urban industrial and my lord, areas monthly income 9,409. Daily calculated 26 ones. Zone B is 8,700 swans. My lord, here, my lord, minimum wages when, my lord, may I put
Anyway, when employer is depositing, what is the necessity of minimum wages?
minimum wage?
Milord, it is Google AI. Milord, the notification is here. It's 7,000 odd. Milord, 7,000.
7,000 of?
7,920.
কবে এটা?
Of 2,000?
2000. Milord, July 2018 to December 2018.
আর এটা কি তাহলে? My lord, minimum wages is not.
That is carpenter. Not carpenter, skilled workers.
Skilled worker.
Carpenter.
But here, my lord, I am handing over is a carpenter. Such as carpenter, your lordship kindly see.
Milord, carpenter, unless Milord he has any particular Milord qualification or any diploma, he is supposed to be treated as a semi-skilled worker.
But in the wages, Minimum Wages Act, it is stated that carpenter should be treated so and so. Now, with regard to the percentage, in this case, how much was the granted? 100%?
No, 80%.
No, in this, the Shankar Dutt.
Shankar Dutt 100%. 70%, my lord, carpenter, my lord, Supreme Court assess 100%. Because he has not.
So it was this what? One limb amputation.
On limb amputation. But here also leg also is necessary for doing carpentry work. And my lord, the Lanet.
এগুলো যে এক্সট্রা এক্সট্রা চেয়ে সরব 10,000 20,000 টাকা করে চেয়েছে
আরেকটা কাগজ কই
Is it the same amputate from above the knee?
Above the আরেকটা কাগজ কই আছে
So according to you, the compensation should be 28 lakh.
Yes.
বলো এগুলো অনেক কম কম দিয়েছে
My lord, I have not changed my lord, the medical expenses as given by the tribunal. But the future medical expenses, I add only, my lord, 40,000. Special diet during treatment, 40,000.
Pain and sufferings?
Your lordship, your lordship, kindly see page 30 of the paper book. But the tribunal granted pain and suffering only 50,000. A person who got, my lord, at the age of, my lord, 31, remaining, my lord, 40 or 45 years, only pain and suffering 50,000. I pray 1 lakh. And loss of amenities only 20,000. He cannot use, my lord, he can use, my lord, with prosthetic leg, my lord. That was not, I have paid. Money, another case I will pay. But future medical expenses, I paid, my lord, only 50,000.
So 10,75,000 is loss of earning capacity.
Loss of earning capacity.
100% 1 lakh
The other is 3 lakh.
Other is, my lord, 3 lakh. In Rajkumar Das case, my lord,
2 lakh 9,000. 10,75,000 plus, you see, this is
5 lakh.
2,34,000.
Now, 20, my lord, your lordships, my lord, seeing my assessment, 20.
No. Regarding suppose loss of earning capacity is enhanced. With regard to others, it is kept intact. Suppose how much is awarded apart from non-pecuniary loss? Not non-pecuniary loss. This pain and sufferings and loss of amenities, it is about
10 lakh.
You see, it is about 2 lakh
1 lakh
34,000.
1 lakh.
No, 10 lakh 75,000 plus 2 lakh 34,000.
2,34,000. And my lord, very recent judgment Supreme Court granted, my lord, is a amputation of leg. Reported decisions where, my lord, is reported 2026 ACJ. এটা একটু দেবেন জজ সাহেবকে।
Yes.
But it is a case, if my case is, my lord, if your lordship takes 100%, then, my lord, this case, my lord, consider the Supreme Court total award compensation of rupees, my lord, 56,83,000 under different heads. Medical bills.
He is a family man.
It is very recent decision, 6/5/2026. Amputation of left leg above knee. My lord, I have bought 3-year judgment. I did not place. My lord, considering I paid, my lord, the entire life, my lord, he has disabled. My lord, I paid 28/13. 20
awarded or only paid?
13 lakh, my lord, was awarded. I paid, my lord, further 15 lakh.
Achha, this decision of 1975, which paragraph you are relying? Three-judge bench of Supreme Court, 1975. Pratap Narayan, yes, Pratap Narayan Singh.
Yes, Pratap Narayan Singh.
Yes, paragraph?
Paragraph, my lord, page 3.
Page 3.
It was a case of, my lord, May 6, 1969.
Yes, 1975. The decision was.
Decision was 75. It's a case of carpenter who lost his, my lord, one limb from his shoulder. Disability statutory banner the 50%. But the Supreme Court consider, my lord, 100%. Because he was unfit for that work.
Yes, that's all. Yes, Mr. Singh.
It's a little difficult for me, Milord, to deal with the judgments what he has cited. The reference is not given. I do not know. Milord, let him.
Pratap Narayan Singh reported decision.
Yes, Pratap Narayan Singh, I remember, Milord. I can deal with Pratap Narayan Singh. Others,
I'm relying Pratap Narayan Singh. And Jagdish I also, my lord, handed over. And other decisions, my lord, I'm relying that was reported.
Yes, when can you come ready?
No, my lord. My lord, your lordship,
let
my
him give
lord.
me the references. I'll be ready on Saturday.
My lord,
Acha, likun to je record.
My lord, your lordship, kindly consider, my lord. Today I am
I will
not.
consider I will not consider your learned friend's
My
prayer.
lord, let him finish, my lord.
He is throwing judgments one after.
Learned advocates for the parties are present. Mr. Bonig, learned advocate for the appellant, has concluded these submissions. Let this matter appear on 1/8/2026 for submission of learned advocate for the respondent.
Milord, at least, Milord, let me get the references.
Yes,
Milord.
give the reference. as well as the decisions. Or else you can take mine.
No, no, actually.
Let him give.
You take mine, you come ready on the next day.
Yes, yes.
Hey,
My lord, top your lordship kindly forward us, my lord. This is a case of 2025.
no, I'll conclude hearing on that day.
Milord, he has taken even that judgment. Milord, it's a difficult, Milord. Your lordship
Taken judge.
sees the conduct.
ইচ্ছিত এই তো দে না
তোমার থেকে কেন নেবো আমি? জজ সাহেবের কাছ থেকে নিয়েছি।
No.
জজ সাহেবের
সিলেক্টিভ করে দেবে না? এটা কি হচ্ছে?
These were my copies. I
জজ
gave it to
সাহেবের
him.
তুমি নিয়ে নিলে আবার
I gave it to him.
বেচে দেবে?
Let him come ready. He will give those copies to me on the next day.
আজব
All
ব্যাপার।
right.
ওইখান থেকে টেনে হাত বাড়িয়ে নিয়ে নিল। ওইখান
আরে
থেকে বাদ
না
দিল।
রে ওইটা দেবো তো তোকে তুই রাগা কি আছে
Yes.
সোজা জিনিস সোজা রাখো না কেন?
Yes, item 6 is also yours.
Milord, item 6 is also mine. আমার পারি না। Kindly convert one second.
My lord, in this case, I appear for the appellant and respondent.
Appellant
Because
and pro forma respondent.
there are two vehicles involved.
Yes.
Out of my lord, the accident, the mother, father died. Now, my lord, two insurance company, one is Bajaj, two vehicles are
No, two vehicles are there.
two vehicles there. One vehicle was insured by Bajaj.
Yes.
One vehicle was insured by National Insurance
Two
Company.
vehicles involved.
My lord, here the award was to the tune of rupees 10,50,000 and odd.
Yes.
Now, my lord, 50-50 was granted by the tribunal.
You're for the claimant.
I'm for the. My client, my lord, the National Insurance Company has satisfied the award.
Yes.
And my lord, I have come, my lord, this appeal
For
for the
enhancement.
enhancement because future prospect was not granted. The
So
my
part
lord,
of the award is satisfied.
part of the award. And my lord, on the other hand, Bajaj prefer, my lord, an appeal against the same judgment, challenging that
They are not involved.
that the my lord, the dishonor of check. That was, my lord, dishonor of check. Your lordship passed the, my lord, the elaborate judgment, Shobade. That your lordship directions upon the all the police stations, all the, my lord, the to notice that the vehicle was not flied in the road is that I will argue, my lord. Shobade covers, my lord, everything, my lord, judgment of the Supreme Court. Pay and recover. At least my learned friend can get pay and recover. But the, my lord, it appears from the evidence that the check was dishonored. That was not, my lord,
You
communicated.
are for the claimants, not for vehicle owner.
Not for vehicle owner.
Vehicle owner is not represented.
Milord, he is partially
My
correct.
lord, first, my lord, I will place my case, my lord. Then, my lord, he
Whatever
says,
it is, Bajaj Alliance is also, you are for the Bajaj Alliance.
yes, my case is, my lord. Kindly allow me to place my case for the enhancement of the, my lord, the award.
First, the involvement be adjudicated.
Involvement is, my lord, no doubt involved.
Enhancement is not a complicated issue, but this involvement and this policy coverage, these are complicated issues. So let this be
Policy
heard.
coverage, my lord, if your lordship consider your lordship own judgment, Shobade, considering the, my lord,
Was this point argued before the trial court?
yes, involvement was not disputed. Involvement was not the involvement.
Only policy.
Only policy. And policy remain intact.
No, in one matter I have directed that yes,
Yes.
it was not within insurance, so right to recover by installments.
As per the Supreme Court. Still, my lord, it was good enough. Indrajit Kaur, Rula, Abhay Singh, many judgment your
Anyway,
lordship
let
follow.
Mr. Singh argue, Bajaj Alliance.
Your lordship kindly, my lord, notice that whether the communication was dishonor of check was communication was properly done or not. Proof.
এই একটা শীট দিন তো কাগজ পেপার বুকটা দিন
পেপার বুক আছে, একটা সাপ্লিমেন্টারি পেপার বুক আছে, একটা সাপ্লিমেন্টারি পেপার বুক আছে।
Lord, in this in this case,
দাদা একটা সাপ্লিমেন্টারি পেপার বুক আছে, তো দেখো সাপ্লিমেন্টারি পেপার বুক আছে।
ইয়েস ওই অ্যাপিলটা দিন আগে FMAT 931
সাপ্লিমেন্টারি পেপার বুক।
Lord, in this case, husband and wife,
এই তো এর মধ্যে আছে।
Lord, they were going on a motorcycle. Both of them died in that accident.
হ্যাঁ, এটা দিলেই হবে।
Against, my Lord, these two deaths, two separate awards were passed by the tribunal. Against these two awards, my Lord, there are two separate appeals before. My Lord, one of this appeal is today before your lordship. With regard to the wife, my Lord, or my Lord, the lady who died, that appeal is not here, not today. But both are, my Lord, the similar matters.
both quantum is challenged.
No, my Lord. My Lord, as far as the husband is concerned, my Lord, learned tribunal just said that there are two vehicles. Motorcycle which was being driven by the deceased.
Now
It was insured by my learned senior friend, Mr. Pahad, National. And my Lord, the truck which had hit, my Lord, this motorcycle, insured by my client. Learned tribunal judgment, as far as the husband is concerned, which is today before your lordship, said let the award be proportionately distributed between both the vehicles. The principal sum of 11,16,000 was awarded, both the insurance company to pay in 50-50. Mr. Pahari has paid, my Lord, national company has paid its 50% share. My client Bajaj is disputing its 50% share, my Lord, on the ground that this vehicle was, my Lord, not insured as the, my Lord, the premium check had been dishonored. That is the issue, my Lord, before your lordship today. Mr. Bonik has come up on behalf of the deceased husband, stating that some more quantum is to be given.
So wife's case is not before today.
My Lord, that is what I am saying, Lord. Wife's
appeal was not there.
Wife, my Lord, separate appeal has been filed. Wrong.
কোথায় হয়েছে ওটা?
Huh?
That has been complied. What my learned?
Oh, so no appeal.
No appeal. And my insurance company has satisfied the award.
It has satisfied the award.
Why did my lord no appeal? Bajaj has satisfied the award.
আমাকে কাগজ দেওয়া হলো যে আরেকটা আছে
না
FMA 2219 of 2016 এটা কি আছে গো সেটা তো একটা আছে
এটা তো আমার appeal.
This was a paper book given to me, FMA 2219 of 2016. This is MSc case.
এটা আলাদা।
MSc case 25 of 2009.
এটা আলাদা।
আলাদাই তো বলছি। That is exactly what I am saying. এটা আলাদা। MSc 25 of this has been given by him to me. He is saying that it does not exist, and this exists in relation to the wife. I do not know, my lord, whether he is correct or is
Kumar
wrong.
Rai is Mr. Bonik's appeal.
Yes. Amol Kumar Rai was the.
Now I am dealing with these two cases. One is this Amol Kumar Rai. The other is this Bajaj Alliance.
My lord, these two matters are today with regard to the death of the gentleman husband.
Yes.
But what I am saying, my lord, since the wife was also. তুমি বলছো যে আমি মিথ্যে কথা বলছি
So whatever is there is with regard to this Amol Kumar Rai. No, here
But the deceased is, in this particular case, his name is Shyamal Kumar Roy, the name of the deceased.
Yes.
Amal Kumar Roy is the father of the deceased.
Okay, okay. Amol Kumar Rai.
Lordship, because husband and wife, Shyamal and his wife.
FMA 2216, okay. FMA 2216 is
Milord,
Shanti Roy and others versus National Insurance
Milord,
Company.
Shanti Roy, Milord.
Shanti Rai come because Amol Rai died. Amol Rai died by
May I clear, Milord? May I clarify?
Yes, yes.
Milord, husband and wife both died. Today, Milord, since two persons died, Milord, two separate claim cases were filed. One for the husband, one for the wife. Two separate awards were passed. In one award, against which today the matter is, Milord, that is with regard to the husband, insurance company preferred the appeal on the ground of, Milord, the check bouncing.
That is Bajaj Allianz versus Shanti Rai.
I'm grateful to you.
Shanti Rai is the daughter of the victim.
No, Milord. Shanti Rai, Milord, since both husband and wife died, Milord, the parents, Milord, of the husband, they were also a party, Milord, in the claim case because the children were mine. So, Milord, the Amal Kumar Rai was the father of the deceased. Shanti Rai was the mother of the deceased. Amal Kumar Rai, Milord, during the pendency of the claim case, he died. So, Milord, Shanti Rai remained as the Milord first respondent in the clause title, the mother of the deceased husband. Now, Milord, what has happened? Today, husband's case is before your lordship.
Yes. The
One
death of
appeal
the
of
husband.
insurance company and one appeal of, Milord, the claimant for enhancement.
Yes,
And
that is why that is our appeal and the counter appeal, Bajaj Allianz
counter appeal.
and this Shanti Roy.
And Shanti Rai. Milord, this is clear as far as today's
Mother of the victim and whatever it is.
and whatever it is. Milord, so this is clear. Milord, that is what is today before your lordship.
Yes.
Milord, what I am saying as far as the wife is concerned, who also died, the Milord wife of this is Shyamal Kumar Roy. Milord, she also died in the same accident. Milord, they were going on a motorcycle. Both died, Milord. So for the wife, separate claim case was passed. Separate award. Against that separate appeal was preferred by my learned friend.
It is not before me.
Milord, that's what I am saying. But he's, Milord, telling lies and I do not know why. Because I have given the number.
Anyway, he's not properly instructed.
Milord, today, Milord, since this award was equally proportioned, Mr. Pahari has, Milord, satisfied his share of award. Milord, I have challenged it on the ground, Milord, of the
It's a short point only.
Short point, Milord, short point. Milord, your lordship, Milord, how I have proved my case of check bouncing, Milord, is that, Milord, my legal officer went before the court and he gave witness. Milord, that is at page number 19 of my lord's this paper book. Page 19, if I'm not wrong, Milord.
Not 221, that is 931.
Lordship.
If 931 ta din.
পেপার বুকটা
তো এফএমএ হয়ে গেছে এখন না এফএমএ 931
না 931 931 এ পেপার বুকটা দিন
931 এটা দিয়ে দাও তো
ওটা এফএমএ তে 931 আছে
931 এ তো আলাদা হবে আলাদা অ্যাপিল আলাদা পেপার বুক
মানে deposition as supplementary paper book I have filed.
So two appeals should be two paper books. Because this is not cross objection.
This is not cross objection.
It is separate
Numbering is again wrongly written. The FMA.
931 only I have annexed the memorandum appeal of Bajaj and the judgment. That was filed.
So why not comprehensive paper books?
My lord, at that time, my lord, I have not, no copy has been served upon me. Insurance company.
Otherwise, it will create some confusion, you see.
No, my lord. My lord, in this, my lord, kindly see the, kindly see the, my lord, FMA 2216.
2216, yes. Amol Kumar Rai, Shanti Roy versus National Insurance. You please check up what is there. Yes, go through this, you check up.
My lord, your lordship, kindly see the supplementary paper book. Only the, my lord, the memorandum appeal. দেওয়া আছে দুজনকে দেওয়া আছে এটা নিয়ে দিয়ে জজ সাহেবকে দাও আমার দরকার নেই এটা দাও জজ সাহেব
See, different appeals, different paper books are
different
prepared.
not different appeal same appeal
Different appeal. It's not cross objection.
Cross objection. My lord, your lordship.
See, two appeals preferred by two parties. So there should be two paper books. Why this one paper book?
My lord, তুমি বলে দাও
প্রবন্ধ আপনি বলে দেন আপনি
Evidence of Bajaj, my lord, page 19 of the paper. In paper.
না না নম্বরটা চর্চা জিজ্ঞেস করছে আপনি এভিডেন্সে কেন ঢুকছেন আগে নম্বরটা তো ক্লারিফাই করা
Supplementary paper book তো দিয়েছে।
নম্বরটা চর্চা জিজ্ঞেস করছে
Supplementary paper book তো দিয়েছি।
Actually, I am concerned with this one. The Mr. Singh's appeal, Bajaj Alliance versus Shanti Roy. So, anyway, judgment is one or the two judgments.
Same judgment.
Same judgment.
Same judgment.
Okay. Let me consider the judgment first then. Anyway, the trial judge held that you have not been able to prove that the check was dishonored.
I'm grateful to you. That is correct.
And whatever it is, the trial court, that is the findings of the trial judge.
My lord had gone through the award passed by the tribunal.
Yes.
My lord, I'll just indicate, my lord, the relevant part. If my lord has gone through already, lordship, my lord, just at the cost of repetition, my lord, the award of tribunal note starts at page 23.
Yes.
Page 23. My lord, is there page 23, my lord? The award of the tribunal starts there.
Yes.
My lord, page 25 at the bottom.
Yes.
On the other hand, is my lord there, my lord? Last paragraph.
Yes.
On the other hand, Bajaj also filed written statement, written objection denied and disputed the claim case and stated that opposite party does not admit the validity of relevant documents relating to alleged vehicle bearing number so and so. Further alleged that the driver had no authority, and furthermore, it is stated, your lordship will not kindly take note, it is stated that insurer had not received any premium as condition for the contract of insurance. But in my written statement and obviously it is there, but in the same page, at the bottom, just below the decision with reasons. Just above that, my lord, the paragraph is starting with, on the other hand, the national did not adduce any evidence. Bajaj adduced one witness and one GD entry is marked as exhibit. Then, my lord, your lordship will kindly, my lord, come in this award itself. Page number 3030, my lord. 30 of this paper book. My lord, second paragraph is starting with but learned advocate.
But learned advocate.
I'm thankful to your lordship. But learned advocate for the Bajaj argued that at the relevant time there was no insurance policy of vehicle number so and so, as because the check issued by the owner of the vehicle had been dishonored. Fact remains, such factum is not proved in due process of law. But I agree that. But I agree to that. Moreover, from the ruling reported in so and so, it is apparent that Honorable Court hold dispute the bar created by the Section 64 VB of the Income Tax Act of the Insurance Act. The apparent is the authorized insurer issued a policy of insurance to cover the bus without receiving the premium, but by reason of provision of Section 147 of the Motor Vehicle Act, it is apparent that the companies are liable to indemnify the third parties in respect of the liability which the policy covered and to satisfy compensation in respect of thereof, notwithstanding its entitlement to avoid or cancel the policy for reason that the check issued in payment of the premium thereon had not been honored.
Here the vehicle owner did not appear.
Vehicle owner did not appear. My lord, this was, my lord, the finding of the learned tribunal judge, and then, my lord, the award was equally, my lord, distributed between both the companies. Now, my lord, I'll invite my lord to come to the evidence of, my lord, Bajaj. My lord, that is at page number 19, my lord, which I had initially, my lord, invited my lord to look into. Page 19.
Yes.
Lord, may I read, my lord?
Yes.
Page 19. Affidavit in chief of so and so of Bajaj. Lord, I, Indranath Rai, so and so, executive of Bajaj. Lord, that I am the legal executive. Lord, same page, page 19, paragraph 3. It is submitted. What is there, Lord? It is submitted that the opposite party, Bajaj, initially issued a policy number so and so. Since the opposite party number 1, Sriram Kohar, page 19, promised to pay premium by check of number so and so of 23,000 odd drawn on Axis Bank. When the said check was presented, the same was returned by the banker for insufficient funds. On 26th June, hence this respondent had not received any consideration for policy number so and so. Hence this policy is void ab initio for lack of consideration. There is no privity of contract between the owner of the offending vehicle and this respondent. Next paragraph, your lordship will kindly have a look. Paragraph 4. It is submitted that in the absence of any contract, this respondent is not liable to indemnify the owner of the vehicle bearing number so and so out of accident dated 15/9/2008. And then, my lord, the IRDS regulation is, my lord, reflected in paragraph 5. My lord, your lordship will kindly come to page number 21, next page, paragraph 6. Is my lord there, my lord? Paragraph 6.
Paragraph 6.
Lordship, my lord, page 21.
Yes.
Evidence of Milord Bajaj. That is para 6, Milord. That in support of the above contention, I am filing the photocopy of the said check bearing number so and so, dated so and so, issued by opposite party, that is the owner, for the offending vehicle number so and so, drawn on Axis Bank. Check dishonor memo issued by Axis Bank. Notice issued to the owner opposite party, dated so and so, regarding the cancellation of the insurance policy. And I pray for making the same as exhibits. Milord, surprisingly, Milord, I find that these were not marked as exhibits. Milord, exhibit is only that general diary which is reflected in Milord the award. Here in Milord, in evidence, every single document, Milord, is being shown to the court, is mentioned here, and Milord, it is stated that it is being marked as exhibits, but somehow, Milord, these are not there. I must admit. Because list of exhibits, Milord, which is at page number, Milord, award starts at page 23, Milord, I had shown to your Lordship.
Lordship, kindly see page 22, next page.
Check dishonor not marked exhibit.
My lord, your lordship, kindly see page 22, next page.
Lord, I'm coming to that. I'm coming to that.
Page 22, next page.
But তুমি বলে নাও আবার জ্ঞান 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 করো।
Yes, next.
Milord, this exhibit, Milord, what I was showing, I had just read out that part, Milord, at page 26.
26.
Milord, it was it is an award of the tribunal, Milord.
Yes.
26, Milord, the exhibit of the Bajaj, Milord, was at the bottom, your Lordship will kindly see, right above, Milord, the decision with reasons, the last sentence, Bajaj Allianz Insurance Company adduced one witness and one GD entry is marked as exhibit. My Lord has seen that. Only this GD entry is marked as exhibit. Now, Milord, in the cross-examination of Bajaj. Because in chief, Milord, I have shown to your Lordship, Milord, what were the documents and everything was there. Milord, the check which was bounced, the bank's notification, the notice given, everything was, I had mentioned.
Yes.
But in the cross-examination, your Lordship will kindly say, Milord, page 22, that is. I filed affidavit in chief.
Page 22.
Page 22, Milord, this is the cross-examination of Bajaj's witness.
Yes.
I filed in affidavit in chief and put my signature. This is the check dishonor letter dated so and so, issued by our company, bearing its number and signature of the authorized person. This is Xerox copy of the insufficient fund, that letter issued by the Axis Bank, Kolkata. This is another letter addressed to RTO by our company, dated so and so, bearing its number and signature. This is another letter addressed to financer by our office on the same date, but bearing no signature. This is the Xerox copy of the check dated so and so. This is another Xerox copy of the receipt in regard to rupees 23,000 odd premium dated so and so. This is the Xerox copy of the registration branch dated so and so. This is another check dishonor letter bearing number so and so. This is the Xerox copy of the check having amount of so and so. This is another insufficient fund note dated so and so, bearing no signature. So, Milord, everything, every single detail or all these things are there. Milord, in the cross-examination, Milord, I did not file any receipt to the court in regard to sending the letter relating to this said dishonor. Milord, in court, it says that it was not filed. I did not file that particular letter. I did not receive any AD card from the respondent. That is true, Milord. From the respondent, that is, Milord, the owner, when these letters were sent,
This
Milord.
is cross-examination by National Insurance Company Limited.
Lordship. Lordship. And then, Milord, the petitioner's cross is also there. Milord, it says, Milord, that receipt I have not filed with regard to that check dishonor receipt, Milord, and I have not received any AD card. Because, Milord, what earlier used to AD card, Milord, we all know invariably, Milord, it is the case of 2008. Milord, AD card we never used to get back. Or,
but afterwards, this speed post,
Milord, now,
this
Milord,
track report.
Yes. And now, Milord, we can get it from, Milord, this Indian Post, from
Track
computer.
report.
So we can get the information. Earlier, it was never there. Milord, and more so, Milord, when the companies used to send these letters, Milord, in blocks, Milord, in a number of every day, Milord, 100, 200, 300 letters were being sent. So, Milord, AD cards with regard to each one, Milord, never used to come back to the company. Earlier it used to happen. Milord is aware of this. It's only, Milord, when subsequently this speed post has happened, it's the news or the information is available on the computer, Milord. We can, in our office, even when the AD card doesn't come back, Milord, we file our affidavit of service showing that they have received. Be that as it may, Milord, AD card was not there, and this receipt also, Milord, that they could not place before the court.
AD card with regard to receipt of this.
Receiving. But, Milord, every single detail Milord, is mentioned here. When was the, Milord, the check received? What was the amount? Check number. When was it sent to the, Milord, the owner's bank? When was it, Milord, refused, or, Milord, it bounced? And when, Milord, the notice was sent to the owner? And Milord, the last part of this cross-examination, I must also read that also, Milord. I have filed document showing the service of our letters. It is not a fact that neither I collected nor I furnished any document showing service of notice upon the issuing authority of check. It is not a fact I have deposed falsely. Milord, somehow, I do not know. Either it was not filed or it is not exhibit. But Milord, the evidence says that every single detail was there of this check bouncing, including the notice sent to the owner, and even the acknowledgement that I did not receive the AD card. That also is the admission, Milord. Everything is clear. But it is somehow it has not gone as exhibits. I must make my position very clear before your lordship. Milord, in these circumstances, Milord, when the check was bound, every single detail was there, and it was before the tribunal. Milord, tribunal never, Milord, stated anything, Milord, that this was there and it was never filed or it was never exhibited. Nothing. Award does not discloses anything of this. But the evidence is there, Milord. My officer stood in the witness box and he gave every single detail of this. That is why, Milord, I say when the check has been bounced and the insurance policy was void ab initio, I have not received any premium. I have stated this in my objection, in my evidence, and during arguments. A learned tribunal has taken note of my argument. And then, Milord, at least in view of the various judgments, Milord, the right to recover should be granted to me. I am not saying, Milord, that he would not get the money. Why is he jumping? I do not know. He will get the money. He is a third party. He is entitled, Milord. But the point is, if insurance company has not received the premium, Milord, the right to recover should always be there. Milord, this is my submission. And Milord, as far as the future prospect is concerned, is the case of, Milord, 2008 accident award of 2014.
How much was the monthly income?
Milord, monthly income, there is no dispute. Milord, it's 10,824.
It is
Less,
rupees?
Milord, 110 rupees, Milord.
10,000?
Milord, gross was 10,824. Less tax, Milord, 130. The net becomes 10,694. 10,694.
Plus future prospect?
Milord, future prospect was not granted because, Milord, this principle was not there. Now is enjoying the benefit of future prospect. So, Milord, that has to be added. Milord, multiplier is correct. Milord, this deduction is no dispute. Milord, interest
50% deduction?
Milord,
Unmarried person?
Milord, yes, wife also died.
Oh, right.
Milord, now the question...
No, parents.
Milord, parents are there.
Parents. So, it has to be 1/3.
Milord, no, difficulty is, Milord, when the spouse is not there at the time of, Milord, filing of the claim case. Your Lordship, Milord, assesses the claim case. The interests are granted from the date of filing of claim case. Milord, on the date of filing of claim case, Milord, wife was not there.
Actually, unmarried person, 50%.
Lordship, unmarried person, Milord, on what scope? Unmarried person, Milord, that he would...
He will spend 50% for his personal expenses.
I am grateful to your Lordship. So, Milord, unmarried person means, Milord, the spouse is not there.
Yes, that means
In
he will
this
spend
case,
for 50% for his personal expenses.
Milord, in this
His
case,
children are there.
Children are there.
So, he will not spend 50%.
No, let it be 1/3. Milord, let it be 1/3. Milord, let him get the advantage of 1/3. Milord, I just falling from your Lordship. Milord, let 1/3 be there. Although wife was not there. Milord, 1/3 has been deducted. Learned tribunal has deducted 1/3. Future prospect, Milord, is to be added to the income. That is, Milord, my humble submission. Interest was 9%.
Now, one question is, did I hear this matter earlier? Because it is transferred to ADJ and I was district judge at that point of time.
Milord, I do not know.
So,
I have to, Milord, I don't...
Trial court records have to be seen. Anyway,
he knows the records. He is, Milord, loudly saying no. Milord, perhaps he
because
remembers.
I had to assign
Milord,
this
your Lordship
matter.
will kindly have a look at the lower court records, Milord.
This is a case of 2009. MSC case. Oh, no, then I have not heard. Because at the time when the judgment was passed, I was there.
2014 judgment was passed.
Yes, I was there as district judge. So from district judge, admission, then assignment.
Lordship.
So anyway, I did not hear this matter.
Lordship. So, Milord, these are the things. Milord, interest was at the rate of 9%. Milord, it should be brought down to 6%. Milord,
Yes.
Milord, so Milord, the...
Here is 9% was awarded.
Lordship, it should be brought down to 6%. Milord, whatever the...
Date of order, not date of filing.
Date of order, yes. My lord, it should be from the date of filing. That is correct. And my lord, the award to be, my lord, proportioned equally, my lord, between both the parties. As my lord,
So anyway, regarding
my lord,
this
future prospect is
future prospect, that is the ground of challenge.
lordship. And my lord, this non-pecuniary, my lord, general damages, my lord, it was 4,500.
4,500
Lordship, my lord, that would also
instead of 70.
instead of 70 at that point of time. But my lord, then also, my lord, 70 was not there because 70 came, my lord, subsequently.
Pronacity.
Pronacity. So my lord, that was 4,500 in view of my lord 163A schedule. So in terms of, my lord, the timing, the judgment is correct. But now, with the passing of time, now the advantage of pronacity, this judgment, my lord, they are getting this extra benefit.
Just like 164 and 163A.
I'm extremely grateful to your lordship. Extremely grateful to you. So, my lord, with this afflux of time, my lord, by default, these extra advantages are to be given. Had it been, my lord, decided in 2014, 16, 17, nothing would have been payable.
By this court?
By this court, yes. Because pronacity was not there. But now with this afflux of time, my lord, these are to be added. They get the extra advantage, my lord. Lordship. So, my lord, these are the two things, my lord. I have spraying, my lord, this right to recover of my share and my enhancement.
Yes, quantum, you are not seriously disputing because this, on the ground of future prospect and general damages. Only this right to recover or right to adduce evidence, these are the two things.
Lordship. Because, my lord, my evidence, my lord, I have read out to your lordship, not in entirety, my lord. It was there. I have made myself very clear there. But somehow it has not come.
Yes, what is your submission?
No, my lord.
No, your ground of challenge is future prospect.
Future prospect and also, my lord, the quantum on other hits. এটা একটু দেবেন তো জজকে?
Lord, again, some papers are, my lord, random.
Not paper, assessment টা।
Every case, my lord, what is this?
আরে assessment জজ সাহেবকে অ্যাসিস্ট করার জন্য তোকে একবার দেখাবো না?
You share it with your learned friend if he is agreeable to
I
that.
have given to other two my learned friends. Two.
আগে দিলে না কেন? সঙ্গে লুকিয়ে কেন কাজ?
লুকিয়ে দেওয়া কি আছে?
আমাকে বলতে হয় কেন?
My lord, your lordship, kindly, my lord, my grounds are, my lord, threefold.
So he has taken future prospect as 30%.
30%. Because the, my lord, at the age, my lord, Shamol Rai was a police constable. He was aged about 45. As per the Sharala Verma or Pranay Shetty, my lord, he is entitled to 30% as future prospects. And my lord, the second ground is that only 4,500 granted. My lord, here I am entitled to, my lord, 84,000 and something.
Where have you stated that? Parental consortium, okay, no question. Parental consortium. Anyway, funeral 1,52,000.
My lord, your lordship, kindly turn to the, my lord, the
No, general damages 1,52,000. It should be 70,000. 80,000 goes.
84,000. 84,000.
So 70,000 goes. So this is a incident of that year. You see, 70,000 is sufficient. 70,000.
70,000. My lord, the Supreme Court says when your lordship is, my lord, passing the judgment, on that date, my lord, the pronunciative principle that every 10 years, my lord, 10% would be increased. My lord, 2017, the pronunciative judgment was pronounced. 2020, 10%. 2023, my lord, 20%. And 2026, I am not arguing.
Anyway, now the question is, you were awarded some 13 lakh something.
My lord has read the story of Shylock, my lord.
Yes.
With every pound of flesh, my lord, every ounce of blood also requires.
My lord, the awarded amount is 11,16,676. That is, my lord, divided by 2. My lord, it comes, my lord, 5,58,338.
Yes, I've gone through your chart.
Yes.
Understood also.
My lord, your lordship, kindly once more, my lord, the pay slip.
No, you see, salary, you see, there is no challenge with regard to the quantum of compensation granted.
So, my lord,
Only you are challenging the quantum of compensation.
yes.
Okay.
Yes.
Income is not disputed. Your challenge is the future prospect and this general damages.
General damages and my lord, one
The others are all correct.
and interest, my lord, interest.
Okay, from the date of filing the claim case,
Yes.
it should be 6%.
But my lord, the insurance company satisfy the award, that part is to be deducted from the my lord total assets divided by 50 to the insurance company this part. That I have
Both will
also
share
calculated.
equally, and whatever is paid or deposited,
That should be deducted.
yes, that should be deducted. So only balance amount should be paid or deducted.
And Bajaj my lord would be yes, one.
Yes, you have anything to submit?
Only thing,
Regarding quantum also, you are not disputing. I'll just record your objection only with regard to quantum. Yes, record an order. Learned advocates for the parties are present. Heard learned advocates. Hearing is concluded.
my lord, I'm relying my lord your lordship judgment. The Shobade.
Hey, this is, my lord, this is what I always object to.
Shobade, your lordship my lord relying on.
Okay, that is pay and recovery. Two cases are there, you see.
Pay and recovery.
One is, you see, insurance policy not valid and check dishonor, that is Shobade. And the violation of the terms and conditions, that is Liraza Bibi. There are two things. Recovery for this insurance premium and recovery for violation of policy terms.
My lord, what I am saying.
Learned advocates for the parties are present.
Then I will get my back the Shobade judgment.
Hearing is concluded. Let this matter appear for judgment on
1st August.
11/8/2026.
এই 11 তারিখ জাজমেন্টটা দিয়ে দিচ্ছি সব আপনি দিয়ে দিচ্ছি সব লিখে দিয়ে দিচ্ছি একটা রেসপন্স
My lord is fixing a particular date, not or CAV.
Yes, yes. কবে এটা 11 তারিখ রাখা হয়েছে তো 11/8.
On for judgment.
Yes.
Grateful to your lordship, my lord.
I want to appeal.
Yes.
শরীর খারাপ বলে
Who is appearing for the insurance? Okay. The matter was heard earlier.
It's very short matter.
No, short, long, whether I've heard it.
But I'll see to it, it won't take more than 5 minutes. তুমি যদি সময় না নাও
না আপনি কোনো সময়
Huh? Paper books.
The case was filed under section 163A.
আমার ব্রিফটা কোথায়?
For the death of the son, the parents of the claimants. The tribunal awarded the sum, but your lordship directed the owner to pay the award since the driving license of the driver was paid. That was the submission of the insurance company. No RTO official was examined, owner was not examined, nothing. Only this point, your lordship. And other point, your lordship, the since your lordship 163A, that is
Quantum is 5 lakh.
5 lakhs, your lordship, with condition, your lordship, investment of
No,
5
question is you are challenging on twofold. One is directing the vehicle owner, the other is the quantum is less than 5 lakh.
5 lakhs, your lordship, provided your lordship, from 2018, there will be an addition of 5% each year, your lordship.
5 lakh?
After 5 lakhs, your
No,
lordship.
where is that provision?
Notification.
After 5 lakh, there will be enhancement.
Your lordship, that was the notification. And your lordship, there are two judgments also on this point, your lordship, one by Justice Ajay Gupta and another by Justice Dipankar Datta himself, your lordship, in recent judgment in 2026. Peter Devan. So this is the amendment of 2018. Kindly see the English version backside, Your Lordship, clause number 2, subsection 2, on and from the day of 1st of January 2019, the amount of compensation specified in the clause A to C of paragraph 1 shall.
This is the incident of which year? The accident of
2012.
2012. Yes, yes. Then you have to confine with
11.
You have to confine with 5 lakhs.
Your Lordship. Your Lordship. Then 5 lakhs will be interest, Your Lordship, from the date of the fine.
My lord,
Yes.
Lord, since the owner has been directed to make payment, owner is not here before your lordship. Owner is not even aggrieved by this order. Your lordship will kindly not give me the express right to recover. I need not prove my case any further. I believe he has served notice upon the owner, and owner has chosen not to come before your lordship. Although the award is expressly against him, my lord is only shifting the liability of owner upon me. So, my lord, if I take the liability of owner, if after proving my case before the court below, your lordship will kindly grant me express right.
Anyway, I shall consider the decision, your evidence, everything. Thereafter, I
But,
shall
my lord, the
come.
right to recover has already been granted. My lord,
No, court has not granted right. Court has
no, court
directed.
has directed owner to make payment, and owner is not unhappy before your lordship.
This is a judgment delivered by Your Lordship in Chandroma saying, Your Lordship. There also the same point was there. Your Lordship directed the owner be examined there, and thereafter, before that, the insurance company would pay.
So the trial court has come to a findings that there is a violation of the policy.
That is why owner has been asked to make payment.
There's
Absolutely
no
clear.
evidence. Before the trial court, there's no evidence.
My lord, your lordship, my lord, I believe some wrong statement is being made from the bar. Your lordship will kindly come to page number 14.
Because I join issue, Your Lordship.
Yes, yes, page number
A
14.
paper books to dekhi.
Only one letter from the RTO was placed.
My lord, the statement is no evidence was there. My lord, I am on
It
that.
was not a evidence, Your
Don't,
Lordship.
please don't elaborate on
Page.
Page 14 of the award passed by the tribunal. My lord. My lord, randomly making statements are, my lord, very unfortunate.
Yes.
Your lordship, page 14 of the award, your lordship will kindly come to, my lord, the 4th paragraph is starting from the word OP number 2. Is my lord there?
Yes.
My lord, OP number 2 is me, my lord, my client. OP number 2 has adduced one witness. But the statement was no evidence was there. Has one witness, namely Indranath De, who is examined as DW1. It transpires from his evidence that the insurance policy of the offending vehicle was valid at the time of accident, but on inquiry, it was detected that the driving license number so-and-so in the name of Mohammed Shamsher was forged and fabricated document, and therefore the driver and the owner of the offending vehicle violated the terms and conditions of the policy, and such insurance policy is not liable for to claim any for any claimed compensation. Then next page, your lordship will kindly see page number 15. Lord, second paragraph, starting with in the instant case. In the instant case, beside the evidence of DW2, a letter is received from Regional Transport Officer and Licensing Authority of Motor Vehicle Department, Cuttack, stating that driving license number so-and-so has not been issued by the Licensing Authority, Motor Vehicle Department, Cuttack, Odisha, to anybody. The statement is being made, no evidence. Lordship will kindly come to the next paragraph. In the facts and circumstances of the case. No, sorry, you said no evidence. Please. In the facts and circumstances of the case and material on record, it is established. It is established that the DL number so-and-so of Mohammed Shamsher, who is charge-sheeted in connection with the instant motor accident, had no valid DL at the time of accident. This is the finding of the court. I gave evidence. The letter of the Motor Vehicle Department was produced before the court, and he's saying no evidence before the court. It's very unfortunate, Millard.
Yes.
And Millard, the finding is the very last paragraph of this page number 15, Millard. In the light of above,
the opposite party owner was directed to pay.
Yes, I'm extremely grateful to you. That is why I say, Millard, the express liberty should be granted to me.
Yes, record and order.
Yes, to my
Learned advocates for the parties are present. Hard learned advocates Hearing is concluded. Let this matter appear for judgment on 13/8/2026.
Not on 13th of August.
13th of August.
Extremely best.
Take din hoye geche to.
But today I took my lord's entire day. So
Yes.
many matters.
Anyway, after all, something is done today.
Something is done. Yeah. My lord, at least tolerating me.
Anyway, I believe we will do the needful on first.
Lord, I shall try, my lord. I'm totally exhausted, my lord. The way, my lord, for this entire week and the last week, the way I'm assisting your lordship.
Yes.
My lord, I'll try, my lord, to the best of my ability.
Because at least I've been able to find certain percentage of the advocates who are ready and willing to come on first.
Lord, every single matter I'm doing, my lord, I'm finishing it off.
Because hardly you see 90% are unwilling.
Lordship,
But at
lordship.
least some 5
Yes,
to 10% are willing. 90% of the entire institution.
I understand, my lord. I know.
At least there are
I know
10%.
that is why, my lord, I say every single matter when I appear, I try to finish it off, my lord, on that day itself.
Okay.